for 44. Double.
Lord, everybody is online.
Is the report received? Your Lordship.
We have filed the affidavit of collector, secretary to WNCD department and CDM also.
I am for the Union of India. Yesterday I filed the affidavit through online. This is the hard.
No, that's it. This is Reshma Raghunathan. Try.
Yes.
CDM and yes. Shibashish.
We have filed the affidavit, my lord.
Yes.
There is the affidavit.
Yes.
We have filed the affidavit.
All right.
Okay.
Yes. Secretary madam is also present.
Right. Right. You've gone through these affidavits?
Your Lordship.
All right. So tell me, what do you find? What have they said?
Your Lordship, as per the cases I have given, Your Lordship, as per their record, 5 cases are true. They are suffering from malnutrition. Even there's one death they are saying because of the of the carelessness of the father here. But she was suffering from malnutrition as per their inquiry report. And one case, there is a conflicting report. As per the report of State Food Commission, there exists a child naming Arjun Hembre. But as per the affidavit given by Women and Child, there doesn't exist any child naming Arjun Hembre. So there is a conflicting report on that.
No. So what are they doing, having found these children to be malnourished?
Your Lordship, as per 9 children that I have given, 5 are malnourished. Sorry, 7, 5, Your Lordship.
No, where is that? You just take us to that
Page
paragraph.
number, Women and Child Department affidavit, page number 10, Your Lordship.
One. Just come to the top of page 10.
Were identified NRC 70 malnourished children were identified who are provided with benefit by concerned your AWC, Asha work.
MAM is what?
MAM.
MAM cases, malnutrition.
No.
No.
Exactly.
Mr. Chakravarti can say, but it's
Yes, Mr. Sharma. Yes. You can tell.
Sir, SAM is severely acute malnourishment, children who are malnourished. Sir, MAM are moderately acute malnourished, children who show signs of malnourishment, but they are in the yellow zone, so their life is not under threat.
All right.
In Dangadi block, there.
So severely and acute are 2 adjectives, but basically it means that they'll have long-term effects, right?
Your Lordship, as per here,
no.
Mr. Sharma, this
Sir, severely and acutely malnourished children are those who are in the red zone. So they are at risk of contracting secondary infections, and they may have severe illnesses. However, sir, there are no recorded evidences of very long-term effects of these, though I am not the right person to comment on this, Your Lordship, but children who are provided timely intervention in terms of enhanced nutrition are able to recover from the severely acute malnourished or SAM category to normal also.
So you say there's something called Purna Ahar program and community-based management of acute malnutrition.
Yes, Your Lordship. Government of Odisha has started this on a statewide scale from the month of November 2022, in which over and above the nutritional support that is provided both by the central and the state government is providing additional nutritional support to children who are in the SAM category. And we have seen results wherein these children have shown improvement and moved to the MAM category and also to the normal category, Your Lordship.
Now, if we come to these 9 cases, 4 are severely malnutrition cases, 2 are medium, right? So this
Yes,
goes
Your
by,
Lordship.
how do you detect this? By weight, is it? By weight of the child or general health condition, obviously?
Your Lordship, there are 3 criteria. I think CDMO Jajpur is there with the on
All
the
right, let
NIC.
him speak. Yes.
So I would request.
Yes.
Collector has given the affidavit at page 6. Your
No, the
Lordship.
CDMO Jajpur is here.
Millards. First, cases, bomb cases are identified in the community and some also in the community by our RBSK team. There is a Rashtriya Bal Swasthya Karjakram. RBSK manager is identifying CBL.
No, sir. My question is, what is the basis for categorizing them as severely malnourished and moderately
That is the height to weight index is there. And standard deviation to height to weight, if it is more than -3, then it will be severely malnourished.
No, so these are, just give us some more details. These are children in the age group of what? 6 to 8 or?
No, sir. It is below 6.
Below 6.
Yes, sir.
And how many are girl children?
Sir,
How many are girl children?
in this case, 3 cases.
No, but he should be sure.
Serial number 5, 6.
C1 series, Annexure C1 series.
Yes,
5,
3,
6, 7.
4. 4 are girl children.
4 are girls.
5.
Yes.
5.
So there's
5.
No, 5.
5. I'm sorry, 5.
5 of which ones?
Out of 11.
Out.
No. See, I think the breakup, if you go back to page 10, breakup is of the 9. 4 are severely malnourished.
Your Lordship.
3
2
are moderately, and 2 are normal, is it?
Normal.
No, of the 4, how many are girls?
5, Your Lordship. As per the name, Your Lordship, 5. 5, Your Lordship. Actually, as per my report, 5, Your Lordship.
Not of the 4 severely malnutrited cases.
Severely 4.
Your Lordship, as per the report submitted by the Health Department, the petitioners had given 11 names,
Yes.
and we have, or the field visit, and CDMO Jajpur may like to add subsequently, as per the field visit, and the Annexure C series are the children who have been found in the village, whose names are matching with the list given by the petitioners, Your Lordship. And of these, girl children are only 2 in my report. One is Sagi Nayak, and the first one, Your Lordship, which is Mukta Nayak. But I would request the CDMO to confirm.
Subbalakshmi.
Your Lordship, if Your Lordship will see the affidavit of the collector, we have given one by one page 6 of the affidavit of the collector.
All right.
Each and every individual, we have given the explanation.
All right.
All.
Page number 92.
Just a minute. Page 6 of the collector's affidavit.
All right.
नहीं, वो मैंने चलो डिटेल ले आके
Right. Sururam.
Surarami Hemram, Sriram Naik, Budhu Chattar, then Bihari Hemram, Mukta Naik, Sagi Naik, Simon Gagrai, Mata Chattar, Puni Hemram, Subhalakshmi Tarai, and Arjun Hemram. These are the. And in each individual cases, we have conducted the inquiry, and the collector has given the details.
Sir, somehow the age is not correctly reflected here, sir. Everyone is said to be a child, but the age is not given. This is strange.
My lord, the fact is these people, they are unable to give the correct age of their children also.
So this is even more serious problem, sir.
But all of them are minors.
No. See, I'm sure
Your Lordship may ask the collector, he will give the explanation.
in rural India, because of this underdevelopment,
Yes.
Actually, malnourishment leads to underdevelopment.
Yes.
So although the child may be, even 10 years old, the child may look to
Look
be
like
a 6-year-old. Correct, Mrs. Sharma? So
Yes, Your Lordship.
it's very important for us to know the actual age. There must be a way of determining this.
Collector Jashpur, sir, if I may allow
Yes,
to speak.
please. Yes.
Sir, we have given the individual details of all the children, sir, along with sir. So to make the main parawise reply a little brief, we have not given the entire details, sir. For every child, sir, the age was determined, sir, as per the register which we have, the records which we have, and in the detail annexures which have been given, the detailed report is there, sir. So for Sunara Hevram, sir, annexure 10, page number 156, sir. The entire age, the benefits which were given to them, the visits by the doctors, the visit by A&M, the entire detail has been given, sir. So age has been mentioned, sir, here, sir. Just to make the main parawise a little brief, sir, we have added the entire details, sir, in the annexure, sir.
So tell me one, so now that you've started this, so they were obviously not receiving these rations, correct?
They were receiving, sir. Sir, I'll say if you allow, sir.
No. How are they still severely malnourished if they are receiving rations?
So they are receiving the ration, sir. In sir, the report which has been given, out of 8 children, sir, only 2 are, sir, 3 children which is there, sir. Kuni Hebram, who's there, sir, she is admitted in Shishu Bhavan, sir, serial number 9, sir. 10 and 11, sir, there is a death. Rest 8 who are there, sir. 2 are Sam children, 2 are ma'am children, and sir, 4 are.
No. My question to you is, if they were receiving rations, how did we have 1 death of a child? How did we have 4 severely malnourished children? Obviously, they were not receiving the rations, sir.
Sir, if I may elaborate a little bit, Your Lordship, this is
Yes.
WCD Secretary. Sir, the mandate of looking after the nutritional status of children has been split across several departments depending on the age criteria. So, sir, Women and Child Development Department, through the network of Anganwadi centers, provides nutritional support to children in the age bracket of 6 months to 6 years. Sir, it is expected that after 6 years, these children are mainstreamed in the regular school education, wherein they start receiving support through the midday meal program. So, sir, the children who are less than 6 years old have been receiving rations from the Anganwadi centers and the ICDS network. That has not been disputed by any agency which has visited the field, sir. But Kuni Hembram, who was found to be severely malnourished, is a teenager, sir. She's an adolescent girl. And because she was suffering from physical disability and cerebral palsy, she was not attending school regularly, is what we have been able to ascertain. So, sir, this is the situation of receipt of rations.
No. I think I'm still not getting an answer to the question. See, 1 child has died. That you've confirmed, right?
Yes, sir.
Yes.
Your Lordship,
Yes.
they have confirmed.
So 1 child has died and 4, even according to you, are SAM, right? So if 1 has died and 4 are SAM and they were receiving these rations, either these rations are not working, or how is it possible that despite receiving rations, they are even moderately malnourished? How is that possible?
Sir, it is very much possible because the rations that are given to children, I have the table in front of me. 6 months to 3 years children are given 4.9 kilos of chatua every month, sir, which is like a ready-to-eat powder, which is mixed in water and consumed by the children, sir. Similarly, children who are in the age group of 3 years to 6 years go to the Anganwadi center, get 1 hot meal there, and get this ready-to-eat about 1.8 kgs per month, sir. However, sir, as the name itself indicates, this is a supplementary nutrition program. So this is supposed to supplement their regular feeding. Their regular feeding is obviously coming through the public distribution system and through their, through the family, sir. So these kids were receiving the supplementary nutrition, sir.
No, but Mr. Sharma, then obviously there is some huge gap here. So we are talking of then persons being so poor that despite lifting rations, despite children getting nutrition, they are dying and some are severely malnourished. How do we fix this? Then all your programs that you are talking of, Purna Ahar and all, will not work.
Sir,
If So,
think they will work,
see,
sir.
that's why I'm
So-
saying let's not be in denial. If they have not received rations for some reason, on paper it is shown they've received rations. When they've in fact not received rations, it calls for an inquiry. So obviously, what is visible on paper is not what is happening on the ground. We can't say both things. We can't say no, rations were given to them, and still we have severely malnourished children, which means the program is not working. And if the solution is again saying no, we'll give these rations, then the solution is not a solution, because if despite giving these rations, we still have malnourished children, then this program is not working.
If I may add, sir.
Yes.
So that one death which has happened, sir, Subbalakshmi Tarai, sir. So there's a medical report which has been given, sir. So if you can see, sir, page number 10, sir. Is,
what was her age, sir?
Sir, age was 6.6, sir. 6 years, 6 months, sir.
6 years and 6 months. All right.
Sir, Annexure 19, page number 227, sir, the detailed report is there, sir. So the child was suffering from cerebral palsy, sir. So there is sir. So on 20th April, sir, when we got the news, sir, a team visited there, sir. So from there, sir, we got to know that the child was suffering from cerebral palsy, and the family has left that child unattended for almost 4-5 days, sir. So
4-5 days?
Yes.
So 4-5 days, the child was left in the house without any support, sir. So that the death which is there, sir, is not because of malnutrition. As a child suffering from cerebral palsy, sir, if it is left for 5 days, sir, the child cannot move, sir, is not able to take care. So the death is completely due to the negligence of the parents, sir. So similarly, sir, when we're talking about the SAM cases,
it's easy for us to say negligence. What was the economic condition of this family? There must be severe poverty, obviously.
Sir, in December 21, sir, we have given them 20,000 rupees out of Red Cross also to support the nutrition benefits, sir. Subbalakshmi Tarai, sir. December 21, sir, 20,000 rupees were given additionally to the family till she was 6 years of age.
No, the family consists of how many people?
5 people, Your Lordship.
5. See, I think this points to a larger issue of poverty. I think we are not addressing this larger issue. Obviously, then all this is so totally inadequate, or it's not reaching them, sir. It's not reaching them.
Your Lordship, there is one more thing which I would just like to flag here, and CDMO is present here, sir. Malnourishment occurs in 2 scenarios. One is lack of nutrition being available, and the second is some underlying health conditions which prevent the children from and the body of the child from absorbing the nutrition which is provided to them. So as your Lordship is commenting, if the rations are provided and if we are claiming that the beneficiary has taken the supplementary nutrition, which in ordinary circumstances is adequate, then why is it that malnutrition is still happening? So your Lordship, periodically...
Actually, may I just interject, Mr. Sharma, we are not even looking at the health condition of the mothers. Yeah. See, anemic mothers, malnourished mothers can't obviously give birth to healthy children, which is why I'm saying there's a acute chronic poverty in these areas. And when we say chronic, it has subsisted over several years. If you don't have healthy people, they can't produce healthy children. So we are just addressing, it's like a very symptomatic addressing of the problem, not a holistic addressing of the larger problem.
Your Lordship is absolutely right. And I think we have also appreciated this in the government segment, Your Lordship, because Ministry of Women and Child Development is supporting now nutritional interventions for adolescent girls from the age group of 14 years onwards in certain aspirational districts which are more poverty stricken. And Government of Odisha is on the verge of bringing its own state funded scheme for adolescent girls in all districts. So we start right from adolescents, try to improve their health conditions, then continue it during pregnancy and childbirth till 6 months, and then continue with children. But at the same time, Your Lordship, we have to identify if the child has an underlying health condition, and that is being done through the health department teams who are moving around. In some cases, they are able to detect also that the child is suffering maybe from some kind of diseases which can be treated through medication. But in some cases, children have slightly more severe complications, and then they are advised to be brought to the nutritional centers or the NRCs, nutrition rehabilitation centers. So your lordship, efforts are on.
Sorry, NRCs, is it? In rehabilitation centers. For Jajpur, where would this be?
In Jajpur Road and Sukinda.
At Sukinda.
And what support will they have? How far from this village to these places?
Sir, we have two, sir. Jajpur Road, CFC, NRC, which is there, sir. It is 8 kilometers from the block headquarters, sir. And Sukinda Road, NRC, which is there, sir, is 22 kilometers from the block headquarters, sir. So it's on both sides of the block, sir. It is being covered, sir.
Yeah, and
Same.
what is the status of these families where these children are? I mean, those must be, the families themselves must be poor, sir.
Yes, sir.
So what are you doing? See, my thing is, both the CDMO and you are here. Are we simply reacting to a problem because it's been pointed out, or is there a larger plan? Because these blocks have been pointed out. I don't know if there are other blocks where there are maybe children who are malnourished, and we are talking of one district, Mrs. Sharma. And Orissa has got 30 districts. I don't know what the position in 30 districts are, and there are many. I think 25% of the population is tribal.
Your lordship.
Lordship is absolutely right. We have 30 districts, and this is not a problem which is only in Jajpur district or in this block.
Correct.
It is across all our districts, your lordship. But
Correct.
Fortunately, I would like to place on record that the state government as well as the central government are no longer in a denial mode. We have Poshan Tracker, through which we are trying to identify as many children as possible so that we can provide them additional support and nutritional interventions, your lordship. So our efforts are on unfailingly.
No, but I'm not seeing what is. See, this is literally an alarm, wake-up call, right? So what have you now put in place? Let's start with Jajpur and then we'll go to Odisha. What have you started?
Sir, if you see, sir, on annexure number 21, sir, page number 243, we have the survey report of National Family Health Survey, sir. So there, if you see, sir, as compared to the rest of the country, sir, the malnutrition, stunting, and weight, it has improved in Jajpur, sir. It is below the
These statistics. Sorry to tell you. Actually, we can't reduce human lives to statistics. All right. In percentages, you may think you've made an improvement. In actual numbers, even one child dying in 2023 in India of starvation, of malnutrition, is really a matter of deep shame for us. And we are claiming, and the Union Health Secretary is here, or what?
No.
Yes.
Whom do you have, sir, from Union of India?
Secretary.
Good morning, sir. I'm Indiva Pandey, Secretary, Ministry of Women and Child Development.
Yes, sir. So you will agree with me, sir, that in India in 2023, we just cannot countenance, we should not countenance even the death of a single child due to malnutrition.
Sir, definitely, but we have put in place a system, and very strong and robust system in last 2-3 years, through which now at least we can say that we know district by district, state by state, block by block, and every Anganwadi we can identify each and every SAM and MAM children. So this system was not there earlier, sir. The details about the child used to continue in the registers of the Anganwadi workers. They did not have anything to actually identify the children. What changes we have made, I'll talk about them briefly. So that we have a Poshan Tracker now where we have put in the WHO definition of SAM and MAM children, sir. And this, the moment you put the date of birth and the weight of the child based on the WHO chart, it will identify whether the child is MAM or SAM and what action is to be taken. There are specific actions which states are supposed to take.
Do you share this information with the state government, sir?
So the data is entered by state government. It is available to every Anganwadi worker.
So can you tell me straight away, sir? Can you tell me straight away, in Odisha, apart from Jajpur, which is the most severely affected district when it comes to SAM and MAM children?
So this data must be available with the state government, sir?
No. You should know, sir. You were there today's hearing. You've been there. You are present here. As a union secretary, forget what the state secretary does not do. As a union secretary, what is the chart in front of you tell you about Orissa?
So we'll get it. It's online. It will take
No,
some time.
no. I'm sorry. What is your name, sir?
Indivar Pandey.
Mr. Pandey, I don't expect this kind of a response. This hearing, all of you knew was going to happen last month, right? What was the last date?
18th, Your Lordship.
This is what I mean by a wake-up call, Mr. Pandey.
Sir.
As a union WCD secretary, you're being told you're having malnutrition deaths in a state. You'd certainly have the complete statistics before you.
So
and what is the plan of action, Mr. Pandey? Did you have a brainstorming meeting with the state government? Because these are all central schemes, right?
These are centrally sponsored schemes, sir, where the central government shares the part of the.
Mr. Pandey, you understood what I asked the collector of Jajpur. If in fact rations are being provided, nutrition supplements are being provided, how are children dying? How are children malnourished?
I'll tell sir what is how it happens, sir. That's what I was coming to, sir. So the issue is in malnutrition happens even to a good child who is healthy. Two very important factors work in, sir. Number one, if proper wash facilities are not adopted, children don't wash hands, they suffer for diarrhea. So diarrhea is one of the biggest causes of malnutrition. Even a normal child who is who is absolutely normal, is getting good food. If he suffers from diarrhea, this may lead to malnutrition. Also, if you have the worms, then you have this problem. For that, for diarrhea, we give the medicines at the Anganwadi center. And also for the worms, albendazole is provided, and every 6 months, children are supposed to be given that. If these two underlying conditions, which are very common and easily removable, are taken care of, lot of cases of malnutrition will go away. Now, second aspect is how do we identify the children? The problem this program was facing for a long time is how to identify. Now, with the technology, sir, we are able to identify in each block, each Anganwadi center, the number of SAM and MAM children. For SAM children, states have a different regime. Firstly, sir, there is something called hunger test, which is performed on the SAM children. If their appetite is normal, sir, after 2 hours of fasting, then they can be cured without any medical intervention, sir. These children are given extra food, which is provided to these children, and over a period of time, they become normal, sir. Normally, SAM and MAM does not lead to any kind of permanent.
Okay, let me ask you, because let me ask you this question. We are in May 2023, right?
Sir.
When were these schemes rolled out, Mr. Pandey? When were all these schemes, the Purna Ahar scheme, the other scheme, when were they all rolled out? Which year?
Sir, original scheme of ICDS started way back in 75, but then it was a limited intervention. Now it is in the new form. It has been rolled out from 2022, sir.
2022. All right. 2022.
In the new format, sir.
No. So you have, I'm presuming from what you said so far, you have detailed granular statistics, district-wise, block-wise, you said. If I remember you right, hearing you correctly. You have block-wise statistics of children in Odisha who may be suffering from SAM and MAM, correct?
Yes, sir.
You have statistics from 2022 onwards?
Yes, sir.
Now, can you tell me, has these the numbers, have they gone up or gone down?
The numbers have, in fact, sir, if we see the NFHS figures for the country.
No. I'm talking of SAM and MAM, sir. Let's be very clear what figures we are talking of.
I'm talking of SAM only, sir. Odisha figure as of now, SAM is 2.26. But if we see NFHS figures,
what is 2.26? It doesn't make sense to me, sir. What is 2.26?
2.26% of the children who are coming to Anganwadis are SAM.
What is the percent? Tell me numbers.
It's Shubha, can you give the numbers of children coming to Anganwadi in Odisha?
Yes, sir. It is about 24 lakhs. So the number of SAM children would be less than 1 lakh, sir, as per the data.
Less than 1 lakh doesn't make much of a difference, which means let's take even 1 lakh. In 2022, what was this figure? In 2023, what is this figure? This is the real test, Mr. Pandey, which is what we're getting now to the crux of the problem.
Sir.
All these schemes, everything looks very good on paper. The actual testing of the scheme, the working of the scheme, these statistics tell you, and we are presuming these are accurate statistics. We are assuming that these are accurate statistics, but what are these statistics telling you? What is the story coming out?
Sir, I have some data which you wanted, sir.
Yes.
I apologize for the delay in pulling it out, sir. So, sir,
Just a minute, madam. Just a minute.
Yes.
My lord, may I see the page 6 of our counter? Further, it is. Lordship got it. It's
Yes.
filed by the Union of India.
Yes.
Page 6, Lordship may see this one paragraph. Center and the portion of the highest standard to the children, the registered in the Anganwadi center is measured every month, and that is uploaded in the portion of the
I'm sorry, Mr. Pandey and Mrs. Sharma. I'm going to pass a judicial order that we don't talk of human beings in terms of percentages. I find it extremely repulsive and unacceptable. Some 0.76%, 0.78%, 2.26%, when we're actually talking of thousands and lakhs of children. I think this way of approaching the problem itself is something in our mindset. The minute we start looking at human beings as statistics, we say, oh, only 1% is malnourished, only 2% is severely malnourished. We forget the numbers behind those percentages. Mr. Pandey, I'm serious about this. And Mrs. Sharma, I think in WCD, health ministries and ministries departments dealing with poverty, we can't talk in terms of percentages. I think we should simply ban this use of percentages. We never seem to realize the gravity of a problem because we talk of it in percentages. In India's population, 180 crores, 1% is a huge number. That's why our approach to the problem seems to be faltering. Mr. Pandey, I want your reaction to this. Should we be talking in terms of percentages like this? And to compare saying, oh, we were 30%, then we are 20% now. And therefore, we've improved. Should we be talking in terms of percentages, Mr. Pandey?
Sir, historically, the data which is collected by the health department through National Family Health Surveys has always put the numbers in terms of the percentages. So that is.
So there is something wrong here, sir. There's something seriously wrong here. Why are we talking of human beings in terms of percentages?
The surveys only do limited number of. They take care. They are based on a sample survey which takes into account a certain number of families only. So based on that, they do the data.
Mr. Pandey, why I'm sounding agitated is this paragraph that Mr. Pandey, the Solicitor General of India, asked us to read. This whole paragraph only gives us percentages. If in the bracket of the percentage you give us numbers, then you yourself will reflect differently on that paragraph.
Sir, let me read out the paragraph, sir.
Yes.
Sir, as per report in April 2023, 1.29 lakh children in Jajpur district were measured, out of which 0.7% were found to be severely acutely malnourished and 2.11% were found to be moderately acutely malnourished, which is lower than the national average. Anyway, the thing is it's just 1.29 and 1%. It's roughly 1,000 children are in Jajpur.
That's what I'm saying, sir. When you say 0.78% and when you say 1,000 children, does it not make a difference, sir?
It does, sir.
It does. So when you say 2.11 translates to how many children, sir? 2.11%?
Roughly 2,000.
Around 5,000, your lordship. Approximately.
We are talking about Jajpur. Total 2,730 MAM children and 1,006 SAM children in Jajpur based on the measurement.
So this is one district in Orissa where you have some 5,000 children who, despite all your measures from 2022 onwards, you say from 1975 was ICDS and you say all the improvement in your measures took place in 2022. Do I understand you correctly, sir?
No, sir. What I meant to say is from 2022 onwards, we are getting the data, granular data from the Anganwadis, and we are able to make a focused intervention, which was not there. Earlier, the system was the children come, you feed them, and you don't have any information about
if
that.
It is focused, if it is focused intervention from 2022 onwards, you should be able to tell me, sir, in Jajpur in 2022, this was the figure. In 2023, this was the figure. So I am hereby demonstrating that all my measures have worked.
Sir, I have some data, if I may be permitted to share here, sir.
Yes, yes.
So, sir, what Secretary to Government of India mentioned, Poshan Tracker, where granular data is available. Sir, in July of 2022, there were 49,205 children who were in the category of SAM for the state of Odisha, sir. In August, this number fell to 48,692.
1 minute. Sorry, 49,205 was when?
In July of 2022, sir.
SAM.
Yes, sir, SAM.
And for whole of Orissa?
Yes, sir, for the whole of Odisha. As per Poshan Tracker, sir, I will clarify this a little more afterwards. Sir, then this number has shown a steady decline. And as on February of 2023, sir, our data shows that we have roughly, it's actually 30,919 children who are coming in the SAM category, sir. However, sir, having said that, though we request parents to bring their children to the Anganwadi centers for measuring on a monthly basis, and some parents do bring, our measurement efficiency is not 100%. Due to various reasons, the child may be out of the village, or there may be some other issue due to which the child is not brought to the Anganwadi center for the measurement on that day. So the measurement efficiency varies in the range of 90 to 95%. In the case, so that would mean, sir, that only if there are 10 children in the Anganwadi center, only 9 have been weighed. So, sir, this data would therefore have certain gaps. So the second issue would be, sir, our Anganwadi workers are mostly class 10 pass. Sir, the Secretary to Government of India, sir, your mic is on. So, sir, in Anganwadi centers, the main measurement is done and weighment is done by Anganwadi workers. About 60%, no, sir, more than 60% of my Anganwadi workers are less than class 10 qualified. In tribal and more difficult, hard to reach, inaccessible terrains, they are even less than class 10 qualified, sir. So, though we have tried our best to build their capacity in taking accurate readings while doing weighing and while measuring the height of the child, which, sir, are imperative, because once you key in the data, the child, whether the child comes in a yellow zone or red zone, it depends upon the height and the weight recording that you make, sir. So, if there are errors there, human errors or mechanical errors, then, sir, there will be a variation between fact and reality. Having said that, sir, we have a system in place where the health team as well as the ICDS supervisory level team moves around and does verification checks. But all I'm trying to say, sir, is that this data may not be 100% accurate.
No, actually, Mrs. Sharma, actually, you will have no means of knowing whether the families actually receive the rations, whether families using those rations, whether that nutritional supplement is actually being, given to the child. How will you know it? There is no way of your knowing it. And do we know how many people are unable to lift? There is another big problem which we noticed in the last occasion. The inability to lift rations for a variety of reasons. So while rations are there to be distributed, some of them are unable to get those rations for completely unconnected reasons like Aadhaar, fingerprints not matching. Correct?
Sir, I will.
It was brought out, I think last time you pointed out that because the fingerprints didn't match or whatever,
Aadhaar card was not there.
Aadhaar card was not there. So you're depriving people of rations because an Aadhaar card is not there. Is it even permissible to do it?
If I may, sir.
Yes.
This is an incorrect statement.
Yes, Mr. Pandey.
The Aadhaar card for children, when we are talking about Anganwadi system, children can get food from Anganwadi only by registering. Aadhaar card is not mandatory, sir. If the mother has a Aadhaar, based on that can be given. If it doesn't have Aadhaar,
sir, I want you to make this, because we've read numerous reports about this Aadhaar being made mandatory for all kinds of things, and also for these rations. There have been numerous reports of people not getting, forget these children, malnourished children and severely malnourished children. We're getting numerous reports. We have a separate PIL, sir, on this food security situation in Orissa. Again, there we had to insist that you should not make Aadhaar mandatory, because same problem. We were finding that rations were not getting distributed.
If I may, sir, I
think, Mr. Pandey, I think you need to put this out in greater measure. What you're telling us today in this hearing, that it's not mandatory, I don't think that message has gone down.
A scheme has been notified. The notification copies have been sent to all the state governments.
So this will not work. People just don't read enough, don't read between the lines. I think you need to put out this even more strongly, that nobody will be denied rations because of want of an Aadhaar card.
We have already done it, sir. We'll do it again, sir.
Yes, because these are telltale. I'm just saying, these are statistics before you. You're seeing what is the ground situation, sir. Today, your participating in today's hearing was so important, because you get a first-hand feedback on how your schemes are working. What is the ground situation?
If on this specific point, sir, I might be allowed, sir.
Yes. Yes.
Sir, the claim which has been made by the petitioner is false, sir. Sir, in Danagadi, sir, we have just given the specific data of Danagadi. In the cycle of January, February, March, sir, 1,047 people who did not have Aadhaar have been allowed to live the Aadhaar, sir. We have given the individual detail of the people who have taken Aadhaar.
The name of the petition, the people I am claiming are not there. Page number 41 to 44. The village, their name is not there. They are there.
So there are two parts to it, sir. So one is denying the ration because of Aadhaar, sir. And second is having a ration card. Sir, the ration card and certain schemes are based on entitlement and allotment, sir. So currently in Jajpur, sir, Danagadi block, 75.73% of, as per 2011 census, people are getting, sir, ration, sir. No person is denied because of Aadhaar, sir. When we discuss about the district of Jajpur, sir, we have currently 9,300 applications which are pending for ration, sir. Out of that, only 84 applications are currently pending in Danagadi, sir. So we take preference for Danagadi and Sukinde area, sir, which are lower. So only 84 applications currently are pending, sir, as and when the vacancy will come, sir. So there are two different parts, sir. One is the allotment which is there, sir. It is the scheme is as per the allotment, not as per entitlement. So 75.73% are getting, sir. Based on Aadhaar, sir, no person has been denied, sir. Now, the specific claim they have made for Danagadi.
Mr. Collector, again, the whole problem is this. 70% are getting, so we will not, even in our sentence, we will not say 30% are not getting. And we will only say percent, so we don't know the numbers. See, our whole thinking has changed because of this, sir. India is a large country of several crores of people. So when we discuss in terms of statistics, in terms of percentages, nothing shocks us, nothing alarms us. In your one district in Jajpur, 30% are not getting, since it's 30%, so it doesn't alarm you. What does that 30% translate to, sir?
So for Danagadi, sir, it will be 34,000, sir.
So if somebody told me 34,000 people are not getting rations, the way it would impact my thinking would be very different from telling me, sir, 70% are getting rations. But this is how we delude ourselves. Everything is working fine because how we project it. See, in management schools and marketing schools, this will all work. Not in actually dealing with human lives. There is a problem, sir. Down the line, I'm finding at block level, at the district level, at the state level, at the central level, all of you speak in terms of percentages.
My lord, there is a eligibility criteria to get this ration. Whether the collector, what he is saying, that 34% they are under that eligibility criteria or not?
Yes, all are not eligible. Question. Yes, are these 34,000 otherwise eligible, sir, to receive the rations?
That is what I was telling you, that only 84 applications, sir, currently are pending with us in Danagadhi.
No, there is some. That's another issue, sir.
No.
See, look at the level of. Mr. Sharma is telling us about the levels of illiteracy, right?
Sir.
And persuading people to come to receive treatment, come to receive help. There is a problem there, sir. People don't know that they can come and ask for things. They're not even aware. So, I mean, in all these areas, it's an alarm call. When we see people dying, when we see people malnourished, severely malnourished, instead of saying, have you made an application? Do you have an Aadhaar card? We must straight away say, how do we save your life? That must be the approach, sir. We're talking of the poorest of the populations. If these schemes can't work for the poorest, what is it for? We must have zero figures in these things, or we must have figures in 2 digits, maximum 3 digits. We can't have figures in thousands in a block, in a district. Mr. Pandey, sorry to go back to you, Mr. Pandey. We are talking of one block in one district in Orissa. What was your reaction? I mean, in the sense of, what is your plan now, sir? How do you propose to fix the gaps here? This is telling you about some gaps, correct, sir, Mr. Pandey?
So our schemes work from taking care of adolescent girls who actually need support, so that when they get married and then they bear their progeny, they are healthy. That is the first step, sir.
Correct.
There is a scheme for adolescent girls which originally used to work for 11 to 14 years. We have changed that to 14 to 18 years because that is our this thing. That has been
so
out.
I'm sorry. If I've heard you right, so 11 to 14, you changed it to 14 to 18.
Yes, sir.
Why didn't you make it 11 to 18?
Yeah, the reason is very clear, sir. 11 to 8. What we want to make sure that up to 14, right to education is there, and children are provided midday meal in schools.
Are they,
As of
sir?
now,
That's not even, that presumption is not correct, sir. I'm sorry to interject you, Mr. Pandey. That presumption is not correct. If you correlate this with the dropout rates in that age group for girl children, it's very high.
So as of now, sir, if you see the gross enrollment ratio for girls, sir, up to the secondary level, it is higher than that for the boys, sir. And particularly for up to the upper primary level, up to class 8, which is covered under RTE, girls' enrollment figures are more than boys at that level. So that with the changes.
This I've never understood, sir. As a common, as a citizen of this country, I've never understood this. Instead of increasing the reach, we say, oh, we'll now shift the group for which we'll give the help. Why?
So
why did we take it off from 11 to 14? Why did we not say 11 to 18? Why don't we increase the reach? Why are we decreasing it?
Sir, our intention is to get the girls in 11 to 14 age group into the schools. We don't want them to come to Anganwadi for nutrition only. It's only from 14 to 18 we were finding that a lot of girls were not covered, that we have brought this scheme, changing it to 14 to 18.
I don't think there's any point in arguing on this. I think it's too obvious for anyone listening to our conversation to be very obvious. Anyway, there's no point in arguing on this. Anyway, so now you've shifted from 14 to 18.
That's one part, sir. Second, sir, we have Pradhan Mantri Matra Vandana Yojana, where we provide almost 6,000 rupees for the first child for taking care of mother during the pregnancy and post-pregnancy, so that she can get better nutrition. This is apart from the assistance she gets from the Anganwadi center, where mother is given take-home ration for this period, entire pregnancy and post-pregnancy, 6 months before and 6 months after. And we are parallelly giving money to her during this period, 6,000 rupees in total, including Janani Suraksha Yojana, sir. So that is one part. And then beyond that, sir, then we are taking care of children from 6 months to 6 years. For 6 months to 3 years, we give take-home ration, sir. Here also, we are going to make one change, which states are aware. We have already written to states that for every time the Anganwadi worker delivers the THR, take home ration to the family for the child or the mother, and alert will go. We have already put this in our system. States have been directed to implement it, and SMS will go to them saying that the take home ration has been delivered to you. So the one point which was a very valid point that you made, how do we know whether the things have reached the beneficiary or not? So for the first time, this is because of technology, we are in that position. That
No, but there'll be people who don't have a mobile phone. Do you know how many people in India don't have a mobile phone, sir?
So, but what I am...
No, are you aware? I'm very plainly asking you, are you aware of how many people in India don't have a mobile? Do you know the statistics, not in terms of, again, percentages, in actual numbers?
So I can't give the numbers.
Okay, Mr. Sharma, how many people in Odisha do not have a mobile? Instead of saying how many people have a mobile, how many people do not have a mobile? Let's ask that.
I apologize, but I do not have those statistics.
Collector Jajpur, do you know how many people in Jajpur do not have a mobile? See, Mr. Pandey is so sanguine that because of technology, now we can find out who has not got. Just look at this. I mean, none of us know this. And we are saying somehow technology will help us track. Mr. Pandey, the purpose of this hearing, and in fact, I've been saying in all PILs, is not to find fault with A, B, C, this government, that government, this collector. All of us are working under constraints. All of you. We understand that. We perfectly understand there are several constraints in your working. But when we identify a problem, the problem is presented itself to us now. All right. We now know that there are SAM children, MAM children, nutritional deaths as a result of malnourishment. We know all that now. It's no longer some hypothetical thing, somebody making up a story or all that. It's a fact. This is why this hearing was after the inquiry by the collector, not before. And we wanted the collector and CDMO to go to the ground and make this inquiry for us. We're not going to rely on anybody else telling us anything else. We go by what you find. Now that you find, now there's this problem before you, we want to know what are your approaches to, first of all, solving this problem and then preventing this problem from recurring. We have wonderful schemes, sir. All your Pradhan Mantri schemes are all wonderful. There's no difficulty at all on that. All right. Your intentions are all wonderful. There's no difficulty on that. But the working, we are now on the working of all these schemes. The schemes are all looking very good on paper. How do we make them work on the ground is the question.
Sir, if I may make a submission.
Yes.
Sir, we have in the state registered about 36 lakhs children, sir,
okay,
who are measured routinely.
All right.
Sir, out of that, only roughly 28,541, actually, to be exact, were found to be SAM in the month of April, sir.
Right.
Sir, I would humbly submit that while each life matters for us, sir, the system is somewhere working.
Yes.
That these deaths which have come as a wake-up call are a one-off factor, wherein also, sir, there are other issues involved, wherein the child, wherein the family has 9 children, and mother is pregnant for the 10th time. So obviously her nutritional status would be slightly compromised, and then the child has cerebral palsy and they're living in a hard to reach area, and they have, for various reasons, they have isolated from the community. Otherwise, the community would also come in, sir. So, sir, my humble submission is that while we are all guilty of that one child's death, yet somewhere the system has worked, sir, because there are so many other children who have benefited, and from July to Feb itself, 10,000 children have improved.
Mr. Sharma, sorry, I mean, this philosophy of glass half full is good in certain instances. You see the positives of everything. Like the classic donut example, the pessimist looks at the whole, the other person looks at the bread part of it and says, oh, there is so much. But that kind of approach in this kind of an issue, somehow for me, and I think I'll speak for Justice Satpathy as well, see, that doesn't get us to actually tackling it. See, this one death of the severely malnourished child, it came out through this one, somebody approaching us and then we asking for an inquiry. We don't know how many such deaths are unnoticed. We don't know that. So to say that there has been only one death and therefore, our systems are working, somehow for me, it's not a satisfactory way of looking at it, because there are many such things probably happening even as we are talking elsewhere in Orissa, and if Mr. Pandey will agree, elsewhere in India. My only thing is this, I think this is all we want to know. What are we now putting in place because of this to make sure that we bring down these figures? Orissa should not have 28,000 severely malnourished children. As Secretary, you will agree. And that must be your goal. How do I make sure that this number comes to zero? If not in the next 6 months, in the next year, in the next 2 years. So what is that plan that we have in mind? And likewise, Mr. Pandey, I mean, I'm sure the Orissa High Court cannot, but you use the Orissa experiment, the example. And if you project it on an all India basis, I'm sure it's an equally alarming situation, isn't it, Mr. Pandey?
So the entire thing depends on how the schemes are being implemented.
Correct.
But
so we need an audit, because I think what this whole PIL has done is it has audited these schemes for one district in Orissa. So what do you think you need to do for auditing it? Auditing the schemes.
So the states have been already advised in this regard. The basic thing is now that states have data at their disposal and they have granular data at each and every block level and Anganwadi level. It is the implementing agencies have to identify each and every child and take special care of those children in particular. Schemes provide for all that. Apart from Government of India schemes, many of the states are running their own supplementary schemes which are doing better. We do hope that with the kind of things which are there, and if it is with the data available, with the
No. Are you, sir? I'll go back to the earlier question. Then, are you finding that from your statistics which you have on your table, the 2022 statistics are looking better than the 23 statistics?
So with the data available, things are improving across the country, sir. And this will be more clear.
No, improving in the sense of, are there still malnutrition deaths happening in India?
Sir, we get our reports from the states. None of the states have reported that malnutrition deaths have happened due to malnutrition.
So now straight away I can tell you that is incorrect, isn't it? We have only looked at one block in one district in Orissa, and for a period of these 5 months, if you actually did the auditing, which is why I'm saying, sir, you might find that things are not what you think they are. Therefore, as a union government, if you're only going to go by what states have told you, the full picture may not come up. Do you have a system of audit, irrespective of independent of what the states are telling you?
So every midway through the implementation cycle of the schemes, we have an audit of the schemes, and I take
it from the union government's point of view, the whole of 2022 and the whole of 2023 so far, there's not been a single malnutrition death in the country, correct?
That is the figure we have got.
And you're confident of it, Mr. Pandey? It doesn't trouble you, this one, what has emerged now?
Any death due to malnutrition is not a pleasant for anybody in the system, sir. We don't want any child or any pregnant lady to have this kind of problem. But yes, for that, the system of, sir, if you say the free ration is being provided during till such time for the eligible category of people, That is one aspect. Anganwadi, again, being a universal scheme, is for all the children who are in that catchment area. They can go and register, their family can register, and they'll get food from there. So from our side, we are very clear. The focus has to be sustained implementation from now on, and which is all we are having meetings with the states every quarter, sir. We review. In fact, today only we are going to have a meeting of Western Zone in Pune, where we'll review the entire scheme.
I think, yeah, apart from this, sir, I'm re-emphasizing the word audit. You must have a mechanism of people going out into the ground from the union government's point of view. See, this is after all, from your budget you're spending on these schemes, correct?
Yes, sir.
So you must be interested in the actual implementation, not through meetings and statistics. Somebody should actually get down there and give you a feedback state-wise.
As I told earlier, sir, we have the provision for that and we get it done. This time also, I think this year, in 23-24, we'll get the schemes audited. So
because
audit of this
statistically, I can only talk of the Odisha example. Statistically, although we say 28,541 severely malnourished children are there today in Odisha, it could be more than that. Would you agree, Mr. Pandey?
Yes. So what happens is the children who don't come to the system.
Exactly.
Sir,
why child is too weak, sir? You saw the cerebral palsy child who died, right? He just talked to us about it.
So
that cerebral palsy child, you expect the child to walk up to a center?
No, sir. For these children, the food is provided at their home. Anganwadi worker goes to the home and delivers.
That's right, sir. So something is slipping somewhere, Mr. That is what is supposed to happen, Mr. Pandey. You're easily translating what is supposed to happen as actually happened. This is the difference in the perception, sir. That is all supposed to happen. But because it did not actually happen, we have the situation on hand now. Yes, Mr. Sharma.
No, sir. In this case, I humbly beg to differ, sir. The child who could not get the ration could not have got it from the Anganwadi center because she was more than 6 years of age, sir.
So there's something wrong with the scheme itself then. See, this is the point I'm trying to make. So somewhere we need to fix these things. We presume since the child will go to school, she'll get it in school, so we need not give it to her once she crosses 6. That presumption may be wrong, Mr. Pandey and Mrs. Sharma. And we presume once the child is now, earlier she was getting it from 11 to 14. Now we say, oh, she has crossed 14. Now we don't need to support her now because she'll get that support in school because our enrollment figures have gone up. It's a presumption again. So all of this goes on presumptions.
Can I make a point here, sir?
Yes, please. Yes, please.
SAM and MAM is only applicable of the children in the age group 0 to 5 years. Sir.
I don't know. I don't know if we say it's only applicable. How do we know a 10-year-old child, a 15-year-old child is not severely malnourished? How are we presuming this?
If there's no definition for 15 years, 10 years, I mean, beyond
that's the point, sir. That's the point.
Beyond 5 years, tables don't apply, sir. After that, child is underweight and suffering from diseases. He is no more classified in those SAM and MAM categories, sir. In that case, the treatment is different because they are treated as eligible for other schemes of the government.
Mr. Pandey, actually, today's hearing is an eye-opener for me, personally speaking. I didn't know we were categorizing human beings like this. And just on paper, therefore, somebody ceases to be malnourished the minute the person crosses 6 years. Deemed not to be malnourished because you are above 6 years.
Sir, I'll humbly submit, sir. It's not my definition, sir. It is the World Health Organization.
Actually, as law persons, we have all these legal fictions, sir. I mean, I can share it with you. Daily, we deal with all these legal fictions. And all the lawyers understand legal fictions. Something is deemed to not exist. Something is deemed to exist. This is classic legal fiction. So in India, if you are above 6 years old, you're deemed never to be severely malnourished. because the scheme does not define you to be malnourished. See, this is how we, by definition, exclude. In law, we do these things. Article 21A is a classic example. Free and compulsory education only from 6 to 14. Therefore, we limit. Somewhere by our definitions, we limit and we exclude. Anyway, so what is the next steps to be taken? I think each of you can give me some idea, suggestion as to what you want, what you're going forward. Let's start with the collector. Going forward, sir, how do you want to see Jajpur free of SAM and MAM? Please tell us.
Sure. So there are two parts to it, sir. The policies which we're taking, and sir, there are certain problems which we face in the field, sir.
Yes.
If I may be allowed, sir.
Yes.
So for Anagadi and Sukinda, these are two areas which are under district mineral fund, sir. So in August, September, we had taken a survey, and there's a supplement called Spirulina, sir. So it is
sorry, you're talking a bit too hard, fast. What is it?
Sorry, sir.
I'm just asking.
One is Danagati and another is
Sir, Sukinda, sir.
Sukinda. Ah.
So these two are covered under district mineral fund. Tanagadi, sir. Tanagadi and
Sukinda.
DI.
These are two blocks.
So these are two blocks, sir, which are covered under district mineral fund, sir. So to supplement, because that fund is available with us, sir, at the district level. So to supplement this, sir, in August, September, we had gone with a survey, sir. 104 children were identified in Danagati.
Sir, can I suggest something? Since you have the fund and Mr. Pandey is there, I don't think anybody will object. Suppose you survey the mothers as well and find out if adults are themselves needing of nourishment, particularly mothers. Are they of good health? So you extend it to women also, sir.
So we'll extend it to women, sir, and sir, with your permission, we'll be doing it for the entire district as well, sir.
All right.
For Danagadi, sir, we have identified 1,300 children who are vulnerable, sir.
Right.
For them, this Spirulina supplement, sir, we are going ahead with, sir. So it is a product which is made out of algae, sir. It has a protein content of out of 100 grams around 60 to 67%. Sir.
Yes.
So that we have done, sir. For Danagadi Sukinda, sir, we already had additional CCI under DMF of 50 children, sir. It is full, sir. So we have already given a work order for additional 200 bedded CCI, sir. In addition to this, sir, 63 children who are there, sir, they were identified and rehabilitated, sir. So we do rehabilitation, sir, based on 2-3 issues, sir. One is if the children is an orphan. Also, if the parents are not taking care of it, sir, through the CWC, sir, Child Welfare Committee, sir. So now, sir, here certain problems which we face are sir, in the cases which have been given, sir, out of these 11 cases, sir, 3 children, sir, Buddhu Chatar, Mukta Nayak and Saji Nayak, sir, who were identified having certain problems, sir, SAM and medical problems, sir. So the parents refused to take them to hospital, sir. So I'm just this, out of these 11 children, sir, I'm giving the details, sir. After that, sir, on 13th, we had asked the Sarpanch to personally go and convince the parents, and the parents have refused to take them, sir. So that we have on video as well, sir. So finally, on 14th, we had to send a video with the police team to finally take these children, sir. So similarly, in this case, sir, so this is, so we are going to this extent, sir. So similarly, if we take the case of Kuni Hebram, sir, so in Kuni Hebram case, sir, the parents, yesterday, sir, she's admitted there. So the father went there and created a ruckus that I want to take out my children, sir. So similarly, in the case of the girl child who has died, sir, Subhalakshmi Tarai, sir, she was admitted to the hospital, sir. The parents fought and took these children out of the hospital, sir. So whenever these cases happen, sir, the problem which happens with us is that the parents, sir, for Subhalakshmi Tarai also, sir, she was admitted for treatment, sir. The parents went there, say, fought, and they took the girl out and gave it in writing that we do not want to get her treated, sir. Similarly, currently we're facing the same problem with Kuni Hebram, sir. So whenever we face these kind of problems, sir, so when we say that the ration has been given to the child, sir, so if I'm talking about the Hebram family, sir, 3 children are covered under supplementary nutrition program. But when the food comes, sir, it is equally distributed between the parents, sir. The eggs are eaten by the parents as well, sir. Rest of the family members as well, sir. So when we see that even if the product is going and this is happening, sir, these are certain ground realities which are we are facing, sir.
No. So that's therefore I think your tribal welfare department has to come in
Sir.
to see how, you can go on, I mean, having other ways of interacting with these populations to increase their confidence. Obviously, they don't have faith or trust in the public health system, which is why they're wanting to take the children back. So how do we, build on that trust? How do we build up the trust is the challenge for us.
So we do it, sir. So in case of Pune,
so I think you should let the other secretary know also, Mrs. Sharma, the tribal welfare secretary, that because this is not a problem of just one department or it is across, right? It will be the WCD, it will be the health, it will be the tribal welfare. Yes. How do we bring up, awareness materials in language that they understand and from persons whom they will listen to? Yes, please carry on, sir. Please carry on.
Sir, I'll just take one moment, sir. So when we discussed the specific case of Pune Abram, sir, the first visit by the team which was made, it was made in 17th October, sir. After that, again on 19th October, the team went and convinced the parents, say they agreed to admit one of the child in the nutrition rehabilitation center, sir. They refused, sir. Finally, in March, we were able to convince with the help of force, sir. So in the cases, sir, which are coming forward, wherever these issues are there, sir, there is a complete, we had to use the police force, sir. So we will be providing this, sir. So these cases, this happens, sir. So parallelly, we need to, we are working with the community, sir, PRI members and everybody, sir. So they are also helping us out, sir. So whenever, sir, there is a gap which is coming, sir, it is coming because in certain cases, the parents are not going, or we're not even asking to go to the extra mile, sir. We're just asking them to support us, sir. So this is a ground reality, sir.
So
I just wanted to...
Have you set for yourself some thing? Because you talked of 1,300 vulnerable children, right?
Yes, sir.
So they are potential SAM children or they are already MAM children?
Sir, out of this, sir, we have 162 children are SAM, sir, and 329 are MAM children, sir. But we have gone beyond, sir, of vulnerable children, which we have identified based on the family conditions, sir.
All right.
Children, yes, sir. So not only restricting to the...
I think in one of those reports, I remember reading what is called a multi-dimensional poverty index. If you look at some of those, what is brought out by the Human Development Index reports that UNDP brings out, I'm sure you're aware of it. It's called multi-dimensional poverty. That is, you're, vulnerable from various angles. It's not just economic vulnerability, but like you said, social vulnerability, access to resources, vulnerability. So you have what is called a multi-dimensional poverty index. I think if you look at that carefully, it might give you some ideas about how to approach this whole thing.
Yes,
so what are you you're looking at a short term, medium term? What are you aiming at?
So we have taken this as a short term and medium term, sir. We have not taken long term goals because we want to achieve in the medium term, sir. In addition to this, sir, we have.
Will the CDMO have a meeting with all the ASHAs of the area?
Sir, already done.
Sensitize them?
Yes, sir.
No.
We had two convergence meeting at that particular place with...
See, all the schemes that Mr. Pandey spoke about, is that population aware of all these schemes?
Most of the people are aware.
Sir,
the local population there, are they aware of all the schemes that Mr. Pandey is talking about?
Yes, sir. So the population is...
Sir.
No, who explains it to them?
Sir, they are aware, sir. Actually, we are having convergence meetings of different departments with us monthly once, and inviting PRI members also. So we are making them aware of schemes, sir.
Because I don't know, it must be in the tribal languages, it will be different. Huh?
That is one problem. But the Anganwadi workers are mostly tribal, and they know both the languages, Odia and the tribal language.
I see. Are the children aware?
So, children, only school-going children, they know what benefit they they are getting.
You'll have to do something, sir, for all this. You'll have to be proactive. See, this is a wake-up call for you, definitely. And Mr. Sharma says it's a wake-up call for the whole of Odisha. But definitely you should make sure that Jajpur does not have a single malnutritional death hereafter. And that the SAM children don't exist anymore. They just, I mean, there should be no need for us to say that there are SAM children. I mean, there must be some way of preventing. I'm glad you've identified the vulnerable children, because we don't want MAM children to become SAM children. We don't want those vulnerable children to become MAM children, correct?
Just one last intervention more, sir. So what we have done, sir, now we have tagged different level of supervisors to these categories, sir. So the supervisors have been, Anganwadi supervisors have been tagged with all the MAM children, sir. They're supposed to visit them once every 15 days, sir. And all the SAM children have been tagged with the CDPO, sir. The CDPOs are supposed to visit them every 15 days to ensure that they have received the ration, sir. Further to check, sir, child
development, sorry?
Protection officer, sir. Block level, sir.
Okay.
Child Development Project Officer.
Protection
Officer.
Protection officer. All right.
Sir.
Each block, one CDPO is there.
Okay.
Sir. So for SAM children, sir, they have been specifically tagged with that, sir. Sir,
all right. Sorry to just interrupt you. Mr. Sharma, is the Odisha Commission for Protection of Child Rights is one, and women, you have a Odisha Commission for Women. Are these, do they have members, or
recently, by the intervention of the Honorable Court, all
the members are there?
Commission is also there, Your Lordship.
Food Commission is also there.
Can we rope in these bodies as well?
Yes, Your Lordship.
We'll put it in our order today. That might help you, but let's get them actively involved in this whole exercise.
Yes.
Yes, Your Lordship.
All right.
Sir, one last point, sir. There are certain policy-related issues, sir, which we cannot take decision at the district level, sir, which is entitlement based on allotment, sir. So if number of ration which can be given, there is a limit to which the cards have been given, sir. It's based on 2011 census, sir. So unless and until those vacancies are created, sir, at district level, those interventions are not possible.
Yeah, one thing which Mr. Pandey told us, and which you need to implement, nobody should be denied rations because of want of an Aadhaar, or for that matter, a mobile phone. See, if our systems are all dependent on these things, somebody will slip through and not get anything. So there must be another way of, providing. We have to reach out to provide. Instead of saying you have not applied, you don't have a mobile, you don't have an Aadhaar. So instead of those negative approaches, we have positive approaches.
Sir, for that point, sir, I was just telling, sir. So for Aadhaar, sir, no person has ever been denied the ration, sir. It is based on the vacancy, sir. So if a vacancy does not exist, if the allotment and entitled is not available with us, sir, so a lot of people who are entitled cannot get, sir. So in cases where we have seen what they are telling that they have been denied because of Aadhaar, sir, no person has been, sir. So in January, February, March in Danagadi, 1,047 people who did not have Aadhaar were given ration by bypassing the system, sir. But there will always be cases, sir, because the allotment for the district or allotment for the state is limited, sir. So there will be a lot of entitled families who will not get the ration card per se.
So what do you propose to do for that, sir?
So that is one issue, sir, which has to be decision as a policy level, sir. The number of people who will be covered under
so, Mr. Sharma, it brings us back to that earlier coverage issue. Actually, we are dealing with that coverage issue. I think Mr. Mishra, Gautam Mishra is, we are dealing with that coverage issue, that other matter.
That's coming up in July.
But it's actually interlinked with this.
Yes. And in fact, I wanted to suggest that my lord may include the school and mass department, because after that 6 years,
right.
So that convergence is required.
Correct.
And there is a mechanism of having this audits that we are looking at. Social audits is a part of that Food Security Act. And you have to have these suo moto complaints, because my lord knows that's what we are raising there, that there's a power to suo moto take action. In that act. That is something which has to be proactively.
Actually, you need to have a state food commission for that.
The opposite part number 8 is the Odisha State Food Commission.
They have members and all that.
Yes, your lordship can involve them also.
All right.
Including that Mahila state.
Right.
Women
School and mass would be very important because post 6, 7, they take over.
Mr. Sharma, then this also involves this issue of increasing the cover.
Yes, Your Lordship.
Nobody's left out of the public distribution system.
Yes, Your Lordship. And that actually, just to clarify, as Secretary Ministry Women and Child Development GOI has said, ICDS is a universal scheme, so there is no issue and there is no denial. But public distribution system, we will be involving the Food and Civil Supplies Department and requesting them to look at the issue which has been raised by Collector Jajpur today, Your Lordship. The state government is aware of it. Let me also mention that, Your Lordship. And they are also working under certain constraints because they are dependent upon the central government for allocation. So I will pose this problem to them, Your Lordship.
All right. Mr. Pandey, anything else you want us to?
So, as you directed, we'll ensure that all the states do the social audit of the scheme so that actual situation in the field can also be ascertained. A third-party check can also be done on the what exactly is happening on the field. We have been impressing upon the states again and again that, yes, earlier we did not have data, we did not have information. Now you have the information. So please make best use of this information to ensure that each and every child who is identified as Sam and Ma'am is taken care of through the system. System is quite robust, sir. It's only a question how sincerely we implement in the field. And one of the issues, sir, I like to mention that in most of the states, I don't know, Odisha ki, what is the vacancy figures? So the Anganwadi worker cannot be replaced, sir. You can't have vacancies at the level of Anganwadi workers and Anganwadi helpers, sir. These are frontline workers, sir. A secretary charge can be held by another secretary. But the Anganwadi worker works in the field, he works in a particular institution. If she is not there, that Anganwadi center will be closed. So we have to make sure that 100% of the Anganwadis are manned at all times. We have also made a policy intervention saying that they should retire only on 30th April of the year so that you can collate all the vacancies at one point and do the recruitment well in time so that on 1st May, every Anganwadi has a worker. Many of the states are doing it, sir. But if we have vacancies in field organizations, sir, the scheme will flounder. That is my earnest request to your lordships and to the states that make sure that field positions are filled up at all times. This is absolutely essential.
So I may also request you, sir, from your level, when you have a scheme, our concern must be to make it convenient for more people to get included in the scheme rather than put in things that will exclude people from a scheme. So I think that should be the basic philosophy or tenet of your approach in having welfare schemes rolled out so that people don't get excluded.
So I'll make 2 points here, sir. Yes. I feel those are very important. Number one, we have the Poshan helpline for the country, 14408.
P-O-S-H-O-N. Poshan. What is it?
Poshan helpline.
What is
basically
that?
The purpose is if any person who is eligible for the benefits from the Anganwadi system and does not get the food or hot cooked meals, he can complain on this number so that we can also intervene in such cases. That is one.
So number two, we need to spread the awareness of this.
We need to spread the awareness of this. Absolutely true, sir. That is exactly what I wanted to come. And sir, we have made one more intervention, sir, which was not there earlier, sir. This has been done in last 6 months. Now, migrant workers, when they used to go to other areas, sir, they were not allowed to access the scheme, sir. We have done it irrespective of the place of your thing. You can go and register at any Anganwadi in the country, sir. And the Anganwadi, for Anganwadi, it is mandatory to register that child and mother in that Anganwadi and to provide the benefits. So this was not there. This migration facility we have provided so that even the children of migrant construction workers or others who are moving to Delhi, Bombay in cities, they are provided these facilities.
All right. So I'll put it down in today's order that that Aadhaar is not mandatory for availing of these schemes. And that you will make this abundantly clear through a fresh set of announcements so that at the block level, whatever district level, it becomes very clear. and that there is no, the intention is to include and not to exclude people. Correct, sir?
Sir, Aadhaar for children, sir, because children, in case of children, sir, if they are, if they
No,
don't
it should
have
not
Aadhaar,
be. Sir, there are adults here who are not getting the rations because of Aadhaar. If the family
Sir.
doesn't get rations, how will they give the children rations? And I can understand if you said irrespective of age, every child will get. But you've
Sir,
divided children. You've said 0 to 6 will give you help, and then again from 14 to 18. But that gap between 6 and 14, you say they are in school, they'll get help there. So that becomes a problem then. Then we can't afford to deny rations even to adults because of they're the ones, the families have to get it for these children between 6 and 14 to get it.
I'll just make a distinction here, sir. Humbly submit that food grains are under NFSA Act. Those are given by the Department of Food and this thing. We are talking specifically of a supplementary nutrition program where for mothers, Aadhaar is mandatory. And if Aadhaar is not there, all the states have been given. We have given to Orissa 9 crores for Aadhaar enrollment kits in every block, sir. So they can keep on doing Aadhaar enrollments parallelly. For children, we have said that if the mother Aadhaar is not there, mother's Aadhaar will work. There's no issue, sir.
No, sir, but let me again say it, because we heard Mr. Sharma say that although the nutritional supplement is there, we don't know if the real rations are still being consumed. So a family with just nutritional supplements for a child between 0 and 6 and not getting rations at all, and if that family does not have a child between 0 and 6, they'll end up getting nothing. So while you may have given those enrollment kits, we can't deny people rations, sir. This is the point being made. Don't deny anybody their rations because they don't have an Aadhaar. Don't deny it. You may insist on enrollment because of the kits that you distribute, but don't make this a point of being entitled and not entitled. It cannot be. You don't have universal coverage of mobile phones, sir. You yourself agree. And all your Aadhaar systems are completely linked to the mobile. Unless every Indian, every child has a mobile, then the potential of denying a person rations is huge. And it's not in a matter of percentages. It comes back to the first point made. We can't see it as percentages. If 1 lakh or 2 lakh people in Orissa do not have a mobile, you have the potential of denying them rations. It cannot be that way.
If I may, sir,
I was talking in the context of limited ICDS scheme, sir. I was not talking in the context of ration because that is not in my mandate. So
I know, sir, but today you saw very well, sir. This is not, this probably involves several departments, but it's a human problem.
Sir, no person is denied PDS distribution system, sir, access to public distribution system based on Aadhaar, sir. There is a clear communication, sir. It has been followed on the district level as well, sir. Only for Danagadi, sir, 2 parts are there, sir. One is there are certain people who are not in PDS system, sir, because of the limited vacancy, sir. But once a person is in the PDS system, sir, no person is denied, sir. 1,047 people, sir, were given.
Getting onto the PDS system is the point, sir. See, what we are told is that to get onto that system itself, you need to have an Aadhaar card or something. This is the problem.
Sir, it is because of the vacancy is not there, sir. It is not because of Aadhaar, sir.
Vacancy. What does vacancy mean? I don't know. What is vacancy?
Sir, there is a limited allotment of or number of people who can be covered in a particular district and a particular block, sir, under the PDS system. It is not a universal thing, sir. So it is denied because of Aadhaar, sir, but because of the number of which we can provide or number of allotment which has received, sir. So that is why I was saying, sir, that it is not a issue at the district or the state level, sir. It is a policy decision for the coverage of PDS, sir. So number of people, whether it is universal or it is limited, sir. So the exclusion which is there, sir, it is not because of Aadhaar, sir. We have made sure, sir. So because of a disability or any kind of person is not been excluded, sir. It is only.
I think you should know, because you may not have been involved in the other PIL. We are dealing with food security, where we are insisting on coverage becoming universal. It's right now not universal, as you correctly said. There we were told that people were not able to get onto the system because of Aadhaar, we had to pass orders. I think Mr. Mishra will bear me out.
Yes.
We had to pass orders to say this can't be the basis of including people in a PDS system. You should know this is the ground reality, sir. I mean, what you are telling us is one ground reality that not everybody in Jajpur will be able to get rations because of limited allotments.
In fact, if what the collector was trying to say is this vacancy is arising because it is subject to, I was hearing him, he wanted to say that it's based on 2011 census. That's what he was trying to say. So that may be a problem also.
Yeah.
2011, we are in
2023.
Probably that's what he indicated. And he said that that's the reason why there are vacancies, subject to what he says.
Correct. All right, sir. We'll just proceed with the orders. Basically, we'll keep this after 2 months. Mr. Sharma, we hope that these figures come down. And if you think we can include the most vulnerable districts of Odisha, if you can give us a few indication of what you would consider the most vulnerable, we'll expand the scope to those most vulnerable districts at least. Not all, but some of those most vulnerable districts. And Mr. Pandey also will have statistics. So you might also give a suggestion which could be the most vulnerable district. We can expand the scope of this petition to. Should it be Malkangiri? Would it be fair to assume that?
Keonjhar
No,
also.
Your Lordship, I have got the data in the meantime, Your Lordship. Since Your Lordship is looking at absolute numbers, the highest number of absolute numbers are in Keonjhar district.
Keonjhar,
but if you go by the number of children as a percentage, but you don't want to look at the percentage, though, Your Lordship, that may also indicate the severity. That if out of 100 children, 80 are malnourished, it is perhaps more severe even if the numbers are fewer.
Right.
In that regard, it comes to Kandhamal, Your Lordship. So in absolute numbers, it's Keonjhar and percentage is Kandhamal.
So can we include both these districts then? Keonjhar and Kandhamal. It will activate your systems there. I mean, re-energize, should I use the word, re-energize so that...
Or Your Lordship, I mean, the state is already there. So
I know.
If Your Lordship desires...
I'm just saying, see, once we focus, we have a sharp focus, something tangible can come out of that. When you deal with the most...
Keonjhar may be included, Your Lordship. It is also a tribal and difficult terrain.
Right.
Your Lordship, one humble submission in continuation of what MWCD Secretary Pandey sir was saying with regard to the presence of Anganwadi workers in the centers.
Yes.
While in Orissa, Your Lordship, our vacancy numbers are quite low, not more than 8 or 10 per district, but there are lingering court cases in which stay orders have been granted. So, Your Lordship, we recently revised our guidelines 3 months back, in which we have set up a grievance redressal mechanism. If a party is aggrieved that he or she has not been selected as an Anganwadi worker, we have clearly defined levels at which that party may approach. So if Your Lordship, if such petitions come before the Honorable Lordships, if they may direct the petitioners to go and first exhaust the grievance redressal remedy, it would help us in reducing some vacancies.
Yeah, you're right. You're right about that. We have a huge number of Anganwadi worker cases. You're very right.
If Your Lordship may at one opportunity allow us to hear them all, if Your Lordship...
No, it does happen. I think it goes back to the ADM. If I remember right, ADM is the appellate authority. And then
Your
it comes
Lordship,
to
we have now made it at the divisional commissioner level for the workers. So first appellate is ADM, second appellate is collector, and then the final review authority is... But if these pending cases could also be maybe sent
to... We are trying our best to deal with those. All right. You say pursuant to the... Anything else you want to say, Mr. Sohen?
If Your Lordship wants, it will be continuing process. Your Lordship may involve Tribal Welfare Department, School and Mass Education Department, Food and Civil Supply Department, and Health Department in this.
Because they'll have to coordinate. Yeah,
they have to coordinate because correct. These four, not only WCD department, these 4 departments have to be involved.
Correct. All right. So, just to wind up the hearing part before I start dictating, Mr. Pandey, thank you for participating in today's hearing, and Mr. Sharma too, and the collector and the CDMO. And the idea is that we all get together to solve whatever we can do to improve lives. So this is not only to criticize or to find fault, but to actually find a solution. All right. You want to say something?
No.
All right. pursuant to the order passed by this court on 1st May 2023, affidavits have been filed by the collector Jajpur, bracket dated 15th May 2023, by the Commissioner cum Secretary to the Government, WCD Department, bracket 13th May 2023, by the Chief
CDMO
District Medical and Public Health Officer, bracket CDM and PHO Jajpur. What's the date of the circuit? 15th May 2023. And by the Deputy Secretary in the Ministry of Women and Child Development, Union of Government of India, date 17th May 2023. Full stop. Apart from Mr. Pandey, Secretary, Women and Child Development, Government of India, the deponents of the other three affidavits have also participated online in today's hearing. Paragraph. The collector Jajpur has with regard to the eleven children whose instances were cited in the petition, given a breakup which confirms that 4 of the 11 children were severely and acutely malnourished, bracket SAM. MAM were 3 children, is it? What is the breakup?
4 children, Your Lordship.
No, SAM were 4.
MM 3, Your Lordship.
3 of the children were moderately, acutely malnourished, bracket MAM. One child, Subhalakshmi Tarai, who was suffering from cerebral palsy and secondary malnutrition, was found to have died. Full stop. The remaining children are said to be normal children. Said to be single quotes normal children. That is not falling within the above categories of SAM or MAM. Paragraph. As regards the child who died, the affidavit of the collector suggests that she had been abandoned by the family. And that prior that and was found dead on 20th April 2023. And that prior thereto, the ASHA had visited the child on 2 dates in January and 1 date in February. What does RBSK stand for?
राष्ट्रीय बाल स्वास्थ्य स्वास्थ्य योजना.
No, K. RSVK is RBSK. What does the collective will be able to tell us? What does RBSK stand for?
सर राष्ट्रीय बाल स्वास्थ्य
Kalyan. Acha.
कार्यक्रम सर.
कार्यक्रम. Rashtriya Bal Swasthya Karyakram bracket RBSK bracket teams. Team is also said to have visited her. Full stop. The finding that, open quotation, as she was suffering from cerebral palsy, comma, she could neither move nor inform the neighbors about the plight, unquote, is a pointer to the fact that there could be a child in need of attention who was unable to get the attention required despite the existence of schemes, both at the level of the central government and the state government. Details are given about the death of another child, Arjun Hemram, whose name, open quotation, does not find mention in the records of, open quotation. MHT stands for?
Mobile health team.
Mobile health
Team.
team of the mobile health team, bracket MHT. Full stop. This is a pointer to the fact that there could still be families and children who don't stand covered by the schemes. Full stop. The fact of the matter is that these are all children in the age group of 0 to 6 and belong to tribal communities. Full stop. The affidavit of the commissioner cum secretary sets out the process of identification of children as falling under the SAM or MAM category, and referral to the Nutrition Rehabilitation Center, bracket NRC, which is stated to be available in each
Jajpur Road and Sukinda.
as far as the Jajpur district is concerned. In Jajpur Road, and Sukinda taluks. Full stop. It is then stated that there are field level workers like the Anganwadi worker, bracket AWW, the ANM, and the ASHA, who are stated to be trained on infant and young child feeding practices. There's a listing of the programs that are currently stated to be in operation, including the Janani Sishu Suraksha Karyakram, bracket JSSK, the Social Awareness and Action for Neutralizing Pneumonia Successfully, bracket SANS, bracket the Sishu Abong Matru Mrityura Purna Nirakarana Abhiyan, bracket SAMM Purna, bracket. Apart from the RBSK. Full stop. There are also said to be village health, sanitation, nutrition days, where regular checkups are supposed to be undertaken of the women and children. For provision of free drugs, lab tests, referral transportation, and so on. Also, then there is the PM Poshan, bracket midday meal program, implemented by the Department of School and Mass Education, bracket S&ME department, bracket of the Government of Odisha, and which is supposed to improve the nutritional status of children in classes 1 to 8 in government, local body, and government aided schools. Paragraph. Statistics wise, Mr. Sharma, who participated online, stated that there are approximately 36 lakh children in Odisha. 26. And 28,541, bracket as of April 2023, bracket, could be stated to be in the SAM category. Stop. In July 2022, this figure stood at 49,205. Full stop. It became apparent. How many will belong to the MAM category? Mrs. Sharma? You may have to unmute.
Yes, sir. Sir, about 86,000.
All right. And approximately 86,000 could belong to the MAM category. Stop. In the affidavit of the WCD Ministry of the Government of India, it is stated that open quotation, as per the report in April 2023, 1.29 lakh children in Jashpur district were measured, out of which 0.78% were found to be SAM, and 2.11% were found to be MAM, which is lower than the national average of 2.26 SAM and 4.75 MAM, unquote. Paragraph. At the outset, the court would like to observe that while discussing issues relating to health of citizens, and in the particular context of the health of children, presenting statistics in terms of percentages would hide more than they reveal about the ground situation. Full stop. Perhaps human lives and human health should, in the present context, not be discussed in terms of percentages, but in actual numbers. Full stop. To have in Odisha in 2023 nearly 30,000 severely, acutely SAM children is certainly a cause for alarm, not just for the state of Odisha, but for the government of Odisha as well, the government of India as well. Full stop. If one were to understand the national percentages of 2.26 SAM and 4.75 MAM, then the problem is certainly and translate them into actual numbers, the severity of problem would become even more evident. Paragraph. Mr. Pandey, the Secretary WCD, Government of India, explained in some detail how the schemes rolled out, beginning with the ICDS since 1975, are meant to improve the health of children and deal with this problem of malnourishment. Full stop. What a petition like this and the report of the CDMO and collector Jajpur tell us is that there are gaps in implementation of all these various schemes, where the benefit of the schemes may not be reaching the people for whom it is intended. Full stop. One fact that emerged in the course of the deliberations was that although the schemes are intended to be for single courts universal coverage, the fact of the matter is that even in a district like Jajpur, the coverage of the population by the public distribution system, bracket PDS, under the National Food Security Act, NFSA, is not single courts universal. Full stop. Today's discussion threw up expressions like single courts vacancies, unquote, which pointed to the fact that not every person is covered under the PDS system. Full stop. Since the distribution of nutrition supplements and rations is only through the PDS system, there is every likelihood that a family which is in need of such rations and whose children are in need of these supplements may not receive them. Full stop. This therefore points to a larger problem of single courts universal coverage, unquote, attempted to be achieved by the NFSA. Full stop. This also explains how the absence of single courts applications, unquote, pending for coverage under the PDS in a particular district may not explain how many people are actually in need of such rations and help, and help with supplements for their children, who may be either in the SAM or MAM categories. Full stop. What compounds this issue further is that all these statistics are projected on the basis of the 2011 census, correct?
Your Lordship.
And not on the actual figures on the ground as of 2023. Full stop. Therefore, the number of persons, single quotes, excluded, unquote, from the coverage of all these schemes could be much larger than what is projected in these affidavits. Full stop. This is a matter for reflection, both by the Government of India and the state of Odisha, when they sit down to address the issue of gaps in implementation of the schemes. Paragraph. The court impressed upon Mr. Pandey that at the level of Government of India, it must be ensured that the coverage under the schemes is increased progressively year after year. And that can only happen if you have systems put in place that incentivize, single quotes, inclusion rather than, single quotes, exclusion. Full stop. The failure to possess an Aadhaar card or a mobile phone, bracket, since the Aadhaar system is entirely dependent on the possession of a mobile phone, unquote, close bracket, or a proper, single quotes, identity, unquote, paper of a particular kind, can result in a child or a family being denied the basic support in terms of food and supplements, which are so essential for basic survival. Stop. The collector, Jajpur, has in his affidavit explained how the absence of an Aadhaar card is not coming in the way of a person being excluded from the PDS. Full stop. He refers to instructions issued on 10th July 2020 and reiterated on 6th January 2023, wherein, open quotation, it has been stated that people not having Aadhaar cards will be provided with ration through bypass system, unquote. Paragraph. Mr. Pandey, the Union Secretary of the Ministry, WCD Ministry, also emphasized that as far as children up to the age of 6 years was concerned, clear instructions have been issued not to insist upon Aadhaar cards to acknowledge entitlement. Full stop. However, the fact remains that a child above 6 gets excluded by definition from the benefit of many of the above schemes that have been listed out, since it is presumed that a child about 6 will be enrolled in a nearby school where such child will get a midday meal. Full stop. This is just a, single quotes, presumption, unquote, as it is evident that there are dropouts or failure to enroll a child in the school system. Full stop. Again, even for help with adolescent children, help for adolescent children, it is seen that while the schemes earlier contemplated that a girl child up to 11 years old of age would receive certain benefits. Now, under the presumption that she would get the benefit in school, the benefit has been restricted to those between 14 and 18. Full stop. Full stop. In other words, instead of increasing the coverage of the schemes for children from age 1 onwards, it appears that specific age groups of children actually get, single quotes, excluded, unquote, from the benefit of many of the schemes. Full stop. This requires a serious rethink at the level of both the Government of India and the state of Odisha. Paragraph. The court takes on board the statement made in the affidavit to the collector, Jashpur, that no person is being denied any ration only because that such person does not possess an Aadhaar card or a mobile phone. Full stop. This needs to be made abundantly clear at both the state level as well as the national level, since these welfare schemes are meant to cater to the needs of the poor, and there cannot be an exclusion on the basis of a lack of an Aadhaar card or a mobile phone. Full stop. This is because of the fact that there are still several individuals who may possess neither, both in the state of Odisha and, of course, in the whole of the country. Full stop. The court is separately dealing with the issue of coverage under the NFSA in FPIL.
That is WPC number 16216 of 2019.
Yeah, WPC Civil 16216 of 2019. Bracket Odisha State Legal Services Authority, State of Odisha. Bracket close. Full stop. Still, what the present case shows is that the issue concerns more than one department. Full stop. It definitely concerns the Women and Child Department, Child Development Department, but also the SNME Department, the Department of Health, the Ministry of Health, and the Ministry of Education, and the Tribal Welfare Department. Stop. The collector Jashpur explained how families belonging to the scheduled tribes are not willing to have the children treated at the public health facilities. And it requires great persuasion and sometimes even coercion to get them to have their children who are obviously in the SAM and MAM categories treated at the CHCs or DHHs. This points to the fact that more active efforts would have to be made by the Tribal Welfare Department to spread awareness of the existence of these schemes and to convince the tribal populations that they are intended to positively benefit them and their children. Full stop. Paragraph. Both the Commissioner cum Secretary, WCD Department, and the Collector Jashpur have stated that concerted efforts will be made to ensure that there is a progressive reduction in the numbers of children falling in the SAM and MAM category in the immediate short term, that is in the next 2 months. And those efforts will be kept up to ensure that there is no child in the SAM category in the near future in Odisha. Full stop. Paragraph. What this petition has brought out is just the situation of a few blocks, that is the Danagadi block and the Sukinda block in Jajpur district in Odisha. Whereas there could be other districts and blocks in Odisha where the situation may be equally bad or perhaps even worse. Full stop. Paragraph. From the statistics available with the Commissioner cum Secretary, WCD, it appears that one such district which has children in the what's the numbers in Kyonjar?
Yes, sir. So 2000 and something, sir. I just 2820, sir.
There are 2820 children in the
SAM category.
In the SAM category, and therefore would require immediate attention. Full stop. The court would therefore like to extend the coverage of the present petition to include the Kyonjar district as well. Full stop. The CDMO and this collector Kyonjar are accordingly directed to undertake visits to the blocks in Kyonjar district in the next 1 month to ascertain for themselves the factual position regarding children in the SAM and MAM categories. But not stop at that. We'll stop. Just like the collector Jajpur has been able to identify the broader category of single quotes vulnerable children and has undertaken to also identify the category of single quotes vulnerable women, unquote. The CDMO and collector Kyonjar will do likewise. Full stop. Unless we have healthy women and healthy adults in general, it is unlikely that the children in such families would be healthy. Full stop. This again points to the larger problem of lack of single quotes universal coverage, unquote, under the PDS system. Full stop. Unless all the concerned departments work in tandem and in consultation with each other, it would not be possible to find a workable solution to improving the situation. Full stop. The court would therefore urge that the secretaries in the departments of SNME, WCD, Health
and Family Welfare,
Tribal Welfare,
Food and Civil Supply,
and food and civil supplies hold a review meeting in the immediate future, that is within 1 month from today. We'll stop. The court directs the secretaries of the Odisha State Commission for Women, the Odisha Food Commission, and the Odisha Child Rights Commission to also be part of these meetings
May I request one thing? Your Lordship may direct the Chief Secretary to call a meeting of all these
All right.
secretaries.
Ideally, the Chief Secretary, Government of Odisha, should convene the meeting in the next 1 month.
And the minutes of the meeting will be
Yeah.
placed on record.
Yeah. And draw up an action plan to achieve the target of complete absence of SAM children in Odisha and a reduction by more than half of the MAM children in Odisha by the end of 2023. Will some of the minutes of this meeting be placed before the court with an affidavit before the next date? Paragraph, while appreciating the participation of the Secretary of the WCD, Ministry, Government of India, the Commissioner cum Secretary, Government of Odisha, and the Collector and CDMO Jajpur in today's hearing, the court would like to emphasize that matters like these are not to be viewed as single courts adversarial, but an opportunity to work for all to work together to find a workable solution to a problem that is acknowledged. Stop. First August.
Deep level.
The order may be
1st August would be
communicated
enough,
to the
I think.
last week of July. You will get.
Your Lordship.
Last week of July.
No, there are too many matters in the last week of July.
1st August is ideal.
All right, 1st August.
Your Lordship may communicate this order to Chief Secretary.
Yes, a copy of this order be sent to the Chief Secretary. Thank you. Thank you, Mr. Sharma. Thank you.
Deep level.
Yeah. Thank you.
Supplementary stress admission item number 1.
It's a matter where we have prayed that in an appeal under the REDA Act, there is a provision for pre-deposit. We had prayed for dispensing with that. That has been rejected. I have come up before your Lordship against that. But what has happened, Lord, these persons who had made a complaint against us, and the order was passed by the original authority directing payment of penalty and others. We have preferred appeal. But in the meantime, there has been a talk of compromise. But what has happened, on one hand, they have passed orders freezing my accounts. I'm unable to draw the money from my bank accounts.
Why is it before this page? What a PR. Impugned order, sir?
Refusing to dispense with the filing of the pre-deposit.
Why is it? What is that to do with all this?
But statutory, kindly see the impasse. On one hand, they have passed the order.
There's no provision for the exemption. After the judgment of the Supreme Court,
that is,
there's no provision for exemption.
It puts the person in such a difficulty. On one hand, there is an order freezing the accounts. And on the other hand, there is a there's a compromise already settled and we have to pay.
It's mandatory, sir. With this court can't do it under 226. It's mandatory.
I told you.
All right. You see, it's the challenge the present petition is to an interim order passed by the OREAT, that is, you can put the full name, Appellate Tribunal, rejecting the prayer of the present petitioner for waiver of the statutory pre-deposit amount for entertaining the appeal under section 43(5) of the Real Estate (Regulation Development Act 2016. Paragraph. Having heard Mr. Ramakant Pantila and Senior Counsel the petitioner, the court is not persuaded to interfere with the impugned interim order full stop, as correctly noticed by the OREAT, the statutory deposit, pre-deposit under section 43 bracket 5 of the Act is mandatory and has been upheld, and the validity of and its validity has been upheld by the Supreme Court of India. You have this judgment, cost title?
Lord, I have. I take judgment. New tech, sir. High tech, new tech. Your Lordship, pardon me, that is one-sided.
No, it's all right.
Just for reference.
That's not a problem. In new tech promoters and developers private limited versus state of UP. The citation we get it from the net. All right. Accordingly, the writ petitions.
May pray not. I may move for defreezing the accounts before the authority.
That anyway you can.
There's some rethinking should be done. I know this just because every door
all
is
this
closed.
was debated because I heard you probably aware. I went through the entire batch of matters in Punjab and in High Court. That's been upheld in this.
Upheld.
All right. All right.
Item number 2.
Here, my lords, we are praying for, if my lord would see, there's a proposal by the RBI at Annexure 8, page 73 for compounding. Page 73, the RBI writes that this is the amount and
Then we'll have to issue notice.
there's a mismatch, they say, and they say that you are allowed to compound. Now, in fact, we have suggested that we are willing to compound under Annexure 25, page 123. So our problem is that the MD has been repeatedly summoned. He did attend. We have given our clarification. The summons would be from page 109 onwards.
And we will have to issue notice, I suppose.
My lords.
Notice is returnable.
I'm appearing for OP number 2, ED, Enforcement Directorate. OP number 2.
We are for OP number 1.
No direction against him.
As far as the application.
So far as the IA, my lords, let them not take any further coercive actions. Will pay off this sum. That's what a specific case is.
Let me submit, madam. So far as Annexure 25 is saying that it is an application for compounding. But there is a specific provision. On that basis, he is to move the application, but he has not moved. Only to stall the proceeding under ED, he has filed this case. Well, that is Foreign Exchange Compounding Proceeding Rules 2000. Rule 44 says that every application for compounding any contravention or these rules shall be made in form to the Reserve Bank of India Exchange Control Department, Central Office, Mumbai, along with rupees 5,000 by demand in favor of compounding authority.
He has not made this application.
So he has not made application.
No, I'll say that. My lord may kindly see our proposal at page 123. We have made it clear. Page 123, Annexure 25. We have said that we therefore request you to please grant us a reasonable time to file our application for compounding with so and so, and we ensure the continuance of by a company.
No. Why aren't you making that application?
Because that takes time. With the application, we would have to give all the amounts and all the details. So
only 5,000 rupees.
No. Apart from that, we have to give the exact bank accounts, the mismatch and all that we will do. In fact, that's a specific case that it will take some time, but it's not that we'll shy away from this.
No. If you had time to come and file this writ petition, by now you could have filed that application.
And also, as per section 15 of the Foreign Exchange Management Act, it says that any contravention under section 13 may on an application made by the person committing such contravention be compounded within 180 days from the date of receipt of this application by the director, enforcement of such officers, and it should be submitted in the prescribed form. So now there is no cause of action to file this case because now since 21 the investigation is going on before the ED, and since 21 he has not raised objection to the proceeding before the ED.
Yes.
Now he has filed the application. Only to stall.
Lord may kindly see the proposal given by us. We'll follow it up by the formal application. Our problems started after, my lords, the ED's intervention. That, my lord, may kindly see.
But why aren't you filing an application? under the prescribed form.
We would do that, my lords. In fact,
do that. See, there's no question of us interfering at this stage if you don't even make that application.
now, my lords, our problem is that suppose they repeatedly call the MD to come and sit in their office. So they have been repeatedly asking the MD.
I'm sure you have departments and people working on this.
In fact, that's the reason why, my lords, we have said let the MD be exempt. Let them not call for the MD.
No, that is separate, completely different. Here you are talking of your proposal not being considered by the Reserve Bank. You've not even made the application.
No. In fact, to be fair, we have just made it. We have just made the request. We'll follow it up with an application. But our problem is that the MD is repeatedly being called their office.
Basically, prayer A is on this compounding issue.
My lords. So far as prayer B
is consequential, but you've not even set the ball rolling on A.
My lords, we have given that request. We'll make the formal complaint.
You make it. First make it. You say counsel to the senior counsel on instructions. You want to withdraw this and make that application, obviously.
We would, man.
Seeks leave to withdraw the present writ petition with liberty to file an application for compounding in the prescribed format, prescribed form in terms of the Foreign Exchange Management Act and the rules made thereunder. And after following up on such application, to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is paid for. No, we would not.
Item number 3.
We put down his appearance.
I am from the VC Miller.
Yes.
Item 3 Miller.
Yes.
This is the public interest litigation where Miller, the Gram Panchayat, without taking the alienation property, now going to construct the community hall, Miller. And the earlier body, the Sarpanch, they identified one place where the community hall will be constructed, and that was approved by the competent authority, that is the BDO and the Tahsildar Miller. But after his tenure, Miller, another Sarpanch came and he chose another place which has not been approved, but the prior approval has not been cancelled. Now they are going to construct the community hall.
Now they are going to construct. This petition was filed in 2019.
4 years.
What are you saying? Now they are going to construct.
My lord, NSR 2 can see.
When did you file this petition, sir? When did you file this petition?
My lord, the collector rejected our petition.
Sir, you're not following the question. 1 minute. I'm going to ask Justice Satpathy to ask you.
When did you file the petition, sir? When did you file the petition?
My lord, 20 Miller, 2020.
13/11/2019.
And you're saying now they are going to construct?
That has not been finished, Miller. Due to
how do you know? How do you know?
Pending of this case, Miller.
How do you know, sir?
Pending of this case, Miller, and they have neither been that has.
How do you know? How do you know that, sir?
My lord, as per the report of the client, Miller.
Which is when? What is the date of that report?
Over telephone, Miller.
When? Now we are beginning to write one screenplay. When did this client talk to you on the telephone? Nothing. You say for the last nearly 4 years, the present petition has been pending with no effective orders. And the counsel of the petitioner is unable to tell the court whether even if the cause of action survives. Stop. Permitting the petitioner to file a fresh petition if any cause of action survives, the petition is disposed of. Right.
Item number 4.
Liberty may be given if they
yes, all granted.
Given.
Item number 4.
Government guidance has been violated, Miller.
One Minoti Ravi High School has started construction over a Gochal land. This is in the knowledge of the revenue authorities. Melody in Annexure 1, page 9.
All right. You say the petitioner's representation bracket Annexure 7 will be examined by the
Tahsildar Bhadrak.
Okay. Tahsildar Bhadrak, and after notice to the petitioner. No, he says district education officer. He's not made the Tahsildar party. Or okay. District education officer Bhadrak, and after notice to the petitioner and opposite party number 5, a reasoned order shall be passed not later than 14th August. And
My lord, even they know
within a week
they
thereafter.
are going to include it in more school Abhijan.
All right.
And Annex 5, which I want to stay, my lord. I has been filed.
Let it be considered first. Yes.
Item number 5.
My lord, item number 5.29 are both are similar items, and Mr. N.K. Sahu, I'm appearing for N.K. Sahu and he's in personal difficulties. That's why.
All right. Counsel, the appellant to state in personal difficulty.
Obliged.
This is on 23rd August.
Item number 6.
Item 6, I mean, VC, my lord, here what has happened, the petitioner is an NGO based at Delhi. Now this Orissa Computer Application Center, they have floated a tender for setting up labs in over 343 schools under the Atal Tinkering Lab, my lord. That is for development of the skills of students beyond 12 years. Initially, the tender was floated on 20th of 11/2022, my lord, with certain terms and conditions. Thereafter, they have revised the terms and conditions so as to possibly to help a particular institution, my lord. So that is the basic stand. They have not given any specific reasons as to why they have changed the terms and conditions of the technical pre-qualification bit, my lord. Though I'm fully aware, as far as clauses of the tenders are concerned, courts have got very limited powers. I mean, to
How is it
interfere.
PIL, sir? Why is it a PIL questioning tender and all? Where's the question of PIL?
No, because here what has happened, so we are trying to protect the public money, my lord, because now what has happened by incorporating the new terms and conditions, and there are 343 schools which are going to set up these labs, and the total investment is 40 crores. And in the revised corrigendum, it says that whoever is selected, he will be automatically given additional schools as and when required, without again calling for fresh tenders, my lord. That is the whole difficulty.
No. So how does that hurt you? Or
no, it's not hurting me in general. No, it's not hurting me in general. It's a overall scenario because only to give benefit to certain persons, my lord, this has been done. And we had given them a legal notice also, and they have not answered to that. At least let them clarify to our notice the basis of changing the terms and conditions, my lord.
So this notice was sent more than a year ago.
No, my lord, no. On February, the notice was sent, yes, February 2022.
More than a year ago. So you could make a
representative to challenge all these things.
Yeah.
They
my lord.
They must have been set up by some rival bidders.
No, my lord, this notice was sent on 7th of February 23. It's a typing mistake. Because the notice is at page 102, my lord.
No. What happened to this tender?
It's not yet. No, it's not yet finalized. That is what I've stated at page 11, my lord.
No, this you stated in. When did
page 11, page 11, my lord. Page 11 of my writ petition.
No, how do you know that, sir? How do you know
that is what the client has won the affidavit, my lord. I am just basing on that.
No, sir. No, I very much doubt. All your facts end in February 2022.
No, my lord. No, because because the tender was floated on 20th of November 2022. Then they got the revised tender floated on 20th of December 2022. So they said it's a matter of just 3-4 months, my lord.
No. After that revision, you don't seem to have made any complaint. That corrigendum is what your legal notice is something mismatch here, sir.
I'll just check the date, my lord. 1 second. I'll just check the date, my lord.
The corrigendum was issued on 20th December, but your legal notice is February.
No, this is February 23, my lord.
Where do you get that? Where is that?
Page 102, my lord. It's a typing mistake, I suppose.
No.
Because the legal notice cannot be precedent to the corrigendum or the tender notice, my lord.
No, there is a full letter. In fact, it's a 17-page legal notice. Only one page you've enclosed.
Your lordship may kindly see the first line of the subject, because they have stated about the tender dated 22/11/2022. So that it has to be 7th of February 23, my lord. Page 102. The first line of the subject, it says legal notice in tender number so and so dated 22nd of November 2022 for proposal for selection of agency for supply, installation, commissioning of auto tinkering lab. So this date is, it has to be read as 23, my lord.
It's not, this is not convincing, sir. This petition is not convincing. If you want, you go to the Lokayukta.
Your lordship may say so, my lord.
Permitting the petitioner to approach Lokayukta in accordance with law, the petition is disposed of. Right.
That's my lord.
Item number 7.
Please, your lordship. The petitioner is elected Sarpanch, alleging construction of a Gochar land, Annexure 3, page 24, is represented before the collector along with other authorities.
All right, the petitioner's representation, bracket, Annexure 3. Where is the proof of that?
Postal receipt is there on page 25.
25?
Page 25, all the postal receipt
shall be examined by the collector.
Collector.
And have to notice the petitioner and giving him a hearing. A reasoned order shall be passed not later than 14th August. We communicated with them a week thereafter.
I may pray that I will submit the order before the collector because the revenue authority is receiving her pending matter since more than 1 month. This cause deal. So collector office may be there that to pay.
It will anyway go to them, sir. All these orders go to them. Anyway.
Yes. Item number 8.
May be your last thing. When the petitioner prays for the opening of the newly constructed high school of the Recta, my lord, all the sophisticated amenities have been installed for the development of the students, my lord. But the school has already been completed.
Where is the acknowledgement of this representation?
My lord?
Acknowledgement.
Where is the proof of delivery of this representation?
That's my Annexure 2, my lord.
Hey, proof.
Proof of delivery.
That by hand, my lord.
Permitting the petitioner to make a fresh representation. And after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
Item number 9.
May I please, your lordship? My lord, in this case, the Sambalpur Municipal Corporation has already demolished 37 households, your lordship, and has threatened to demolish another altogether 570 households without arranging for their rehabilitation, your lordship. Within 2 days, they have said, your lordship, all these households.
PIL. This is not a PIL, sir.
My lord, it's a slum dwellers, your lordship.
They're not. That doesn't make it a PIL.
My lord, the person who is
not a PIL, since the petitioner is seeking relief for all the members of the petitioner association.
Lordship, he is the president, secretary, but they are individual households, your lordship. They will be affected.
They're all members of this association, I suppose.
No, your lordship. They are just they're slum dwellers. They are not necessarily members.
Why are they not coming forward then?
Your lordship may kindly grant a stay, and they will.
After we grant a stay, they will then decide to come.
Because in
nice strategy this is.
Your lordship, in 2 days they will demolish. They will demolish.
You should have brought them to the court, sir.
My lord.
They should themselves file. Counsel to the petitioner seeks leave to withdraw the petition with liberty to the individuals who may be affected to themselves file a petition. Disposed of is withdrawn with liberty.
Obliged, your lordship.
Item number 10. Item 10 is Sattaparda, my lord, covered by lordship's judgment, my lord.
Which one, school or college?
My lord, this is college and direct payment.
Direct payment, college matter. Covered by the Sarita.
Item 11.
So item 11, I'm for appellant, sir. So behavior escadas is due to personal difficulty, sir. For illness, sir. Due to illness, sir.
Okay. Thoughts for the appellant stated to be unwell. What is your name, sir?
So mine no power, sir. Behavior escadas, sir. Account general.
What is his name?
What's your name, sir?
My name is Pandan Mahanti. Behavior escadas, sir.
It is stated that Mr. S.K. Das counsel for the appellant is unwell. List on 5th September.
Item 12. 12, 13, 14, 15, 16, 17, 18 and 19, my lord, Sattaparda.
Which is school?
My lord, all the colleges. I'll again check about all the colleges, my lord.
College matters.
Yes, college.
Okay. The direct payment or granted?
Direct payment, sir.
Direct payment. Okay. All right.
Item number 20, at 20, 21, 22, 23, 24, 25, 26, 27, 28. All are college direct payments.
College direct payment.
College direct.
Sarita Parade. Right.
Item 29 only. Item number 30.
Item 30, election fix it to 28th August.
28th August. All right.
Item 31. 31 is my lord Saptapada.
Which one?
My lord college.
College direct payment.
Yes. Item 32. 32 may I please. The impugn order is at page 14, my lord. It's a first day disposal. But should we kindly see the, with due respect, my lord, here the counsel for the respondent made a submission that similarly situated persons who have got interim orders in their behalf, in their favor, are being given the benefit and others are not being given. That is the only reason why it has been allowed. Dr. Should we kindly see page 14. Now the learned single judge has recorded his submission that other similarly situated people who have been given.
All right. You said notice returnable. 13 September. Stay in the meanwhile.
Item 33. 33 is Sartapada, my lord.
Which
college
one?
matter, direct, college matter, direct payment, Sartapada. 34 also.
All right.
Item 35. Item number 35.
So there are many defects in your petition.
Sir, in person I have not.
Many defects, sir. You have to cure the defect. List on 1st August. Defects we cured in the meanwhile.
36.
1st August, you cure the defects in the meanwhile. Yes. All right.
Item number 36. Item number 37. 37 and 38 job contract for 14th of September.
14th September. All right.
Item 39.
39 is a writ appeal, my lord, challenging the judgment passed by the honorable single
Is
judge.
for orders, I think there are 1, 2, 3, 4, 5 defects. It's for orders. I think it's.
No, if my learned senior is not otherwise ready on merits, then I can take time for
Fine, but the matters are not taken for admission by the orders. We must pay respect to that.
All right.
Lord, since it's a disqualification matter, as per the
I have been reinstated. As per so what disqualification? A defeated candidate is before your lordship.
One just
Instead of
sentence.
taking recourse to tribunal, he
One
goes to
just
the
sentence,
collector.
if my learned senior Mr. Acharya
Executive
will
channel
permit.
has become very, very profitable for nowadays.
One just sentence, please.
Yes. Let the defects be removed thereafter one sentence. Why
Lord, what I am trying to pay your lordship is one just prayer, one just sentence. Look, since as per the appellant, since a disqualified person is holding the office, let a short date be fixed in the meantime.
There is absolutely
remove it
it's a
and
wrong
can be
statement. Why this is an elected representative?
I said as per the appellant.
Yeah, there is a High Court.
Appellant is always subject to commit wrong.
No stay of vacation. So
No
vacation
stay
will happen.
That's
right. That at least should not have been objective.
All right. 28 June.
28 June. Do I'll remove it.
List on 28
Let
June.
everything
Defects
you
we cured in the
are
meanwhile.
posting in August, I think.
No. Lord, I am not.
Not less than 30 orders.
I'm not staying.
No,
I'm not extending the vacation.
I'm happy. So, but let it be not after any time because I'll be out.
Okay, 28 June will do.
I'll be going abroad.
28 June after reopening the
It's a fresh man. 28 June. Yes, right. All right.
Item number 40.
40. State is the appellant. In the impugned order, the honorable single judge has said that equal quantity measure of land, equivalent land should be given to the person concerned whose land has been taken. So that is not within our scheme. And we can give money or something like that. And direct payment also. That land cannot be given. It is in Bhubaneswar. It is in Bhubaneswar. So notice may be issued.
Notice returnable on 13th September. Stay in the meanwhile.
Stay up. Not stay the impugned. Obliged.
Item 41.
May I please, let's see. There is the writ appeal, and this matter relates to the illegal registration of cancellation of power of attorney by the district sub-register Puri in gross violation of the provisions of the Registration Act and the Indian Contract Act. In this case, my lord, the DSR Puri has registered unilaterally the cancellation of an irrevocable power.
Defect not removed? Some defect? You have to pay your own colleagues. Bar association fee, welfare stamp not placed. You cure the defect. We'll have it on the opening. You say list on 23rd June, defect we cured. All right.
Item 42.
My lord, state is the appellant. The land involved in this case is a huge patch of land in Sambalpur district. And what has happened, my lord? If this respondent got an ex parte decree, and decree. Against that, we have filed the appeal. Appeal is pending. And in the meanwhile, some other stakeholders, this is a government land. School is there, school field is there. School has also filed a suit, which is pending in the civil court for playing for the decree. In the meanwhile, he has filed a mutation petition. The Honorable Single Judge has said that you dispose of the mutation petition. If this is the only direction, then we would have no objection. But if your Honor, Lordship will see page 66 of the brief, of the appeal memo, page 66, the Honorable Court has said that since you have lost the case in the suit, everything is there. So that means the Honorable Court has directed to mutate the land in favor of the petitioner. So we say that since the appeal is pending, another suit is pending, so we dismiss the mutation case. That order has already been passed. Now they have come up with a contempt case by saying that on the basis of the observation of the Honorable Single Judge in the impugned order, the mutation ought to have been allowed. Our only ground is that the appeal is pending, suit at the instance of the school is pending, so we cannot allow the mutation in favor of a private individual in respect of the huge chunk of government land which is under litigation, locked in litigation, and we are pursuing the litigation. And so for this reason, he has also filed a contempt petition. So I pray that this appeal may, because it is all civil cases, and this appeal may be
impugned order.
Yes, my lord. The direction is to in accordance with law if there is no illegal impediment.
No. Just see the 29.9 is what you're challenging. Page 100.
29.9. Yes, page 66.
Acha, what is page 100 is also same date. Anyway.
WPC 26407 of 2021.
Oh, see. Page 100 also is a similar order.
That is another order at the instance of the school. That is, this is the impugned, page 66. I'm just placing para 3. Mr. Parida, Learned Counsel for the petitioner submits that.
Simply says notice returnable. 18th September, there should be stay of the impugned order till that.
Item number 43.
43. Pending seal of just last order, my lord.
It will continue after lunch.
Item number 43.
My lord, the last occasion, ordered 18/4/2023. Lordship directed us to take instruction whether one-time assistance to the parents of the patient suffering from that disease can be enhanced at par with the state of Bihar's notification. My lord, I have given to my lord notifications. The government has notified it.
All right.
Dated 6/5/2023.
All right.
We are grateful, Your Lordship, that they have agreed to disburse 10 lakhs as a one-time assistance.
Certain procedures has to be followed. Lordship, kindly see 1, 2, 3, 4, 5, 6. We have given.
That will adhere to, Lordship.
Yes.
The collector has been given the responsibility.
Undertaking they have to give.
All right.
Lordship, one more thing, if I may submit, I've given 2 orders of the Delhi High Court, recent May 3rd, Your Lordship. Lordship, may kindly see page 23, para 16, Your Lordship. Page 23, para 16.
Yes.
A complete chart of the treatment which has been given to all the petitioners in these cases is set out below. So these are the petitioners before the Delhi High Court who have been receiving treatment. Trials have been conducted, medicines have been approved, and they have been receiving treatment. These many patients, Your Lordship.
Right.
All I would request is the union before this honorable court to include the petitioners before this honorable court and prepare such a chart so as to we can map out as to who's receiving treatment and at what time and how much time will it actually take.
Right.
Because they have also raised a concern at para 22 where they say in this present batch of cases, the court faces an extreme situation where almost 40 children who are before the court are likely to suffer physical and mental injury and deterioration of health if further funds are not released for their treatments. Thereafter, at para 25 at page 29, they say, a perusal of the above would show that the lapse of budget has also been confirmed in the affidavit by Ministry of Health and Family Welfare, Union of India, to the tune of almost 193 crores. The said affidavit also demonstrated that as against the elapsed budget, only a sum of 7 crores was spent between 2018 to 21. So there's a budget issue that is not the problem. They don't have insufficiency of funds. They have the funds, but probably due to somewhere it is lagging or there's some red tapeism or the petitioner, or should we need to delve a little deeper with the union only on this so that these petitioners can receive the treatment? Is that all I'm praying for?
My lord, I'm just clarifying that. My lord directed to give treatment. We have met all arrangements, my lord. Thereafter, this referral, 9 hospitals are there, list has been given. The 2s are coming, and in the meanwhile, one set news is that one boy is died and another is there. So immediately the instruction is given, those hospitals can given such a treatment, they are referred into. As regard to the funds are concerned, my lord is last occasion directed the State Council to come with a concrete proposal, how much aid you are giving. We have already have a scheme. On that scheme, if he is covered, then definitely he will cover money. But as regard to treatment is concerned, we are giving, but we have specified those for this treatment, particular aims are there, they can give a treatment.
No. What he's saying is in Delhi High Court, they presented a chart showing status of treatment of each of the patients and the last date of administration medicine. He says a similar chart can be provided to them.
Yes, it can be done. It can be done. Yes, there are no issue.
All right. You see, Council of the State Government has placed before the court a copy of a notification dated 6th May 2023, whereby the one-time financial assistance provided to each living patient suffering from Duchenne muscular dystrophy has been fixed at rupees 10 lakhs, open quotation, to meet requirements towards electric wheelchair, appropriate physiotherapy, genetic tests, and treatments on higher institutions, etc. Stop and quote. The procedure for disbursal of the financial assistance has also been set out in the notification. Paragraph. Counsel for the petitioner has placed before the court copy of an order dated 3rd May 2023 passed the Delhi High Court. In contempt case bracket C 415/2022 bracket Master Medan Jhavar versus Rajesh Bhushan bracket, where in para 16 in a tabular form the status of treatment and the last date of administration of medicine to 43 different patients suffering from DMD have been set out. Paragraph. Mr. Padi, learned DSGI, states that a similar list can be prepared in respect of the persons who have been provided treatment for DMD pursuant to orders of this court.
My
Which
lord,
would include the last date of administration of medicine to each of them and the present status of their treatment.
my lord, only problem with that. My lord, may I audible, my lord?
Yes, please.
My lord, this Delhi, there is a treatment and they can give instruction. Lordship may provide us whoever patient is treatment in whichever hospital. Suppose we have referred a patient to Delhi, we can get the information from Delhi. Suppose we are giving a patient to the Hyderabad, we are getting information from Hyderabad. So we will get the information. The concerned aims may be provided the information
Correct.
accordingly. We will prepare.
Yes. All right.
Lordship may reflect.
What else needs to be done?
Lordship, that is all. That when this chart comes on board, if they file an affidavit as to the status of treatment of each of the children, at least it'll speed up, the process will speed up of procurement of medicines, because in this chart we can see, your lordship, that 50 lakhs is allocated by the union against each of the patients.
No. What are the other directions? Anything? You don't need to keep this pending now.
No.
The said chart be provided to counsel for the petitioner within a period of 4 weeks to enable the petitioners to follow up on their treatments. All right. No further directions are called for. The petitions.
The last one, 350028/2022. The same order also covered this one. Also.
Correct. All three.
That may be indicated.
All right.
Lordship is finally disposing of the patient.
Yes. No need to keep it pending.
Yes.
If it's not,
You see, if there's any difficulty in faced by any of the patients suffering from DMD in receiving treatment or getting financial assistance in terms of the orders passed by this court, it will be open to them to always apply for directions.
Obligation.
Last two cases, Mr. Bhukta is appearing with me. Last case, Mr. Sanjeev Shah is appearing.
All right. Right.
Obligation.
Item number 45.
My 45 plus September direct payment college.
Direct payment.
My lord, I am appearing for the opinion number 1, my lord.
46, 47.
46 also same, my lord.
And 47 also same.
Okay.
All direct payment college.
All right.
Item number 48.
48, I am for the respondent. Before my learned senior start, my lord, I appeared, but my name in the list is wrongly, instead of Prabodh Naik, it is Prabhat Naik. I only came to know after lunch, before lunch. So I pray convenient to any date, there is an entry mode. What a date.
Here, my lords, it is he's latching on to this place. It's an officer's mess. He's continuing there in spite of that period being over. So, my lord, may kindly see the order of the Honorable Single Judge, which is at page 59. The Honorable Single Judge says that the period of commencement of contract is reworked and the writ court decides the date at page 59. And he's not leaving, it's an officer's mess. He's not leaving that place. In spite of these orders, now I'm told that the learned district judge in a parallel proceeding has passed an order staying his continuance. So this, my lord, may kindly see.
How come he went to the district court after approaching this court?
After this, there was a state court order passing eviction orders that he has challenged before the district court. In fact, after losing before the single judge, again he filed a writ after this writ appeal. There also he lost. Thereafter, he has gone to the district court and the district court has now passed its order of status. So he has circumvented. The period is long over. He's not leaving that place. It's an officer's mess. And this is purely in the realm of contract. A list of dates and points, if my lord would see, the Honorable Single Judge has reworked the date of commencement of contract. If my lord would see from page 59.
So he's running a club, is it? Seafarers Club?
Seafarer, it's an officer's mess. Seafarers Club. The contract period is over.
Well, it's not half story. Let my learned senior, I will submit the briefing. Here is a case what my learned senior challenge the Honorable Single Judge order. Honorable Single Judge please to pass an order in consonance with the terms of condition. Kindly see the order, your lordship, page 59. They have as per the condition, they counter affidavit, they stated the period will be commence November 2015. But counter affidavit, they specifically came to the true fact that it will operate from the day, my lord, that is 8 June 2016. Your lordship kindly page 59.
So if you count 5 years from there,
7 years, your lordship. There is the extension. What I am submitting, my lord, the 7 years. There is the extendable 7 years. Now this date,
7 years is over in 8 June.
my lord, there is some development. What I am trying to submit, your lordship. In 7 years, they have accepted the writ appeal absolutely infructuous, your lordships. The order of honorable single judge accepted by the Paradip Port.
Then why are you going to the district judge and all?
Yeah, my lord, yes, my lord, they have accepted and they have taken a rent from, my lord, this is not that I am only their charity, they have given the rent also, my lord. For that, they have taken rent and your lordship that
who's giving it to you for free anyway?
Yes, your lordship. And your lordship kindly see the mark. They have accepted that the mark, your lordship, 8, my lord, the date 8. This just mark, your lordship. So the order without refunding any amount, without following any notice, they passed an order under the Public Premise Authority Act, your lordship. So my remedy is before the unlearned district judge. A matter is subject. So in view of the acceptance of the order of honorable single judge by the Paradip Port Authority, the writ appeal is become infructuous.
No, what is the acceptance? I don't understand.
My lord, your lordship kindly have given the copy that. Your lordship kindly the mark, your lordships.
No.
Yes, your lordship.
5 years from 2016, that's it.
No, my lord, here is, my lord, your lordship is the hearing the writ appeal, and in writ appeal, the learned single judge pleased to pass an order. The date of operation of the club will be on 8 June 2016, your lordship. My lord, that has been accepted, your lordship, kindly the order of the 13 March.
If you take, sir, 8 June 2016 as the date of commencement,
yes.
What is 5 years from there?
My lord, 2021. Then your lordship 2 years extended.
Who extended?
My lord, that is the extension clause also, my lord.
No, where clause is one thing. Have they actually extended?
No, my lord, they have not extended.
Then
what they done, my lord, what they done, your lordships, they have invoked the court of, my lord, the Act of Public Premises Eviction Unauthorized Act, my lord. They invoke that matter sub judice before this.
Then you withdraw your writ petition itself. Then the whole order should go.
Yes.
Then you are only doing forum shopping then.
No, your lordship, I will withdraw, but that is dispose of writ. How can I, my lord, withdraw?
Then we'll set aside the
Yes, my lord.
Your lordship, the imposed order is infructuous, my lord. Because it is
not infructuous if the single judge entertains these kind of writs. The contract is rewritten, my lords. My lord may see the list of dates, what has happened. He submitted, my lords. My lord may see what has happened in this case, the list of dates given by us. This writ shouldn't have been entertained at the first place. My lord may kindly see. 29/9/2012, work order was issued by the Seafarers Welfare Association for a period of 5 years. Now, here, my lord may kindly take that clause which is relevant at page 32. The clause is there. Clause 5 of the work order at page 32 of the writ appeal provided for commencement of the contract from the date of commencement of work, with a further stipulation that the contract period in any case will commence from 1/21st day of the issuance of the work order. Now, this clause has been rewritten by the Honorable Single Judge. My lord may take note of this.
No. The single judge says it is an admitted position that the commencement was from 8 June 2016. Is that right?
And refers to paragraph 10 of the counter.
Yes.
Now, my lord may kindly see the counter is at page 43. Page 43, what paragraph 10 says? From where that admission came, that my lord may kindly see. Paragraphs 9 and 10, page 43, last line. That a work order annexure 2 to the writ petition was issued by so-and-so on 29/9/2012. This date is very important. In favor of the petitioner company so-and-so for manning of so-and-so for 5 years. As per clause 5 of the work order, the petitioner company shall furnish club cum hostel and deploy staff for operation within 120 days from the issue of work order. Accordingly, an agreement was entered into by so-and-so on 7/11/2012. Paragraph 10, my lords, very important, that the petitioner company failed to provide the services of the seafarers as detailed in the work order. Hence, the petitioner company was served with several notices. But the petitioner, white letter dated so-and-so, committed that by the end of 2015, they shall start providing the services. Accordingly, white letter dated 14/8/15, the petitioner company was allowed time till 13/12/15 for so-and-so. But finally, company started providing services of seafarers from 8/6/2016.
This is taken as
this is taken without taking the previous. That means he will take advantage of his own wrong.
Yeah.
There will also can come to clause 4. My learned senior has clause 4 of the page 27. What the clause says that what I am submitting my learned senior the contention that read court could not have been entertained the jurisdiction. You will also be in the read counter affidavit. The no has they have stopped that this cannot be adjudicated in the read petition. That is the only raised in the first court, in the appellate court. This. So,
how can you rewrite the terms in
this is not rewrite. Your lordship, page 27. Kindly come to page 27 clause. These say that the contract period will be 5 years, commencing from the actual commence or operation of the Port Seafarers Club or from 121 days of the
or from 121st day.
So the commencement has they have
whichever is earlier.
Which is earlier, sir. You're missing out the most crucial thing, whichever is earlier.
That period they have extended period now accepted the rent, Lord.
The question is, when did the contract commence? It's 120 days from the date of the work order or the actual date of commencement, whichever is earlier.
Yes.
The 120 days got over much earlier.
Similar, they have extended.
You have very conveniently forgotten that important phrase, whichever is earlier.
Your lordship kindly again come to paragraph 10, your lordships. The counter affidavit.
Yes. They are all that. You just now read the whole of para 10 only.
Yes, I'm just, my lord, they have extended what date, your lordship? That period was extended. That I am again replacing, your lordship. 8/9, my lord, accordingly, the what paragraph? Accordingly, by letter dated, there is a letter, my lord, extension. Letter annexed to the petitioner company was allowed to time, my lord. The time was extended up to 31st December 2015 for providing that the commencement they extended up to December 2015 and the operation was on June 2016. So according to
you started providing.
Yes,
the point is you delayed. They didn't allow you till June.
They have allowed, your lordship, December 2015.
So if you count 5 years from there,
your lordship, so what I'm submitting.
How can the judge say it will be 5 years from June then?
December, they have extended up to December 2015. The contract was extended from the will commence.
What is 5 years from December 2015, sir?
2020, your lordship.
Then you argued that it was accepted by the single judge that it commenced only on 8 June 2015. Even then, from 8 June 2015, 5 years is over. Over.
Exactly. For
21, 8 June 21.
Exactly.
For there's a question of you continuing.
My lord, what I'm submitting, my lord, 8 June, your lordship is correct. My lord, the period is even if assuming for 8 June, your lordship subject, because your lordship kindly, this is a matter of equity there. On 8 June 2016, the Paradip Port also in respect of other proceeding under the PP Act, they accepted the order of honorable single judge, which have provided that the date of commencement is 8 June.
So if you insist on arguing, we'll ask you to, irrespective of all those proceedings, ask you to hand over possession.
No, my lord.
No. We'll go by your submission that 8 June 2015 16 is the commencement date. You say, yes, sir, 5 years from that date is all that I can stay. So according to you yourself, you have to hand over on 9 June 2021. Today we are in May 23. So you have no option but to hand over.
This is a different proceeding, my lord. I have entitlement.
You want to argue this also?
Yes, lord.
You want to insist on arguing this also?
Sorry.
So you first hand over. No, you first hand over. You hand over possession, we fix it, you hand over possession. Because you want to argue. See, the question is, you want to clutch on to everything. Single judge has decided in favor, clutch on to that. District judge has given you stay, clutch on to that. Don't give up either.
I'm sorry, my lord.
Don't be sorry. You went before the single judge. You don't have to be sorry. This is only abuse of process of court.
I will not argue.
Knowing fully well that the period has expired, you file a writ petition.
In view of Joshi Technologies, the writ is not maintainable. It's a purely contractual dispute. It's not a statutory dispute vis-a-vis a statutory contract. My lord, if I may show the paragraphs, the writ should not have been entertained at the first place. Paragraph 70.
No, but what happens? See, the point is we set aside the impugned order, he still stays in possession. This is the whole problem.
At least if my lord sets aside the order, we will work out our amendments there. But now, because of this,
that's okay. Then we'll straightaway dictate the order. You say the challenge of the present writ appeal is to an order dated 25th October 2021, passed by the single judge, disposing of writ petition civil 18458 of 2019, filed by the respondent against the appellant Paradip Pro Trust bracket PPT for a direction to the PPT to allow the petitioner to operate the Seafarers Sport Club bracket here after the club in question bracket till 1st August 2024 as per clause 4 of the agreement. And thereby quash an order dated 16th September 2019 passed by the PPT declining to treat the commencement date of the contract dated contract / work order dated 29th September 2012 as 31/12/2015 paragraph. By the impugned order, the learned single judge has in para 5 held open quotation, the period of contract is to be reckoned from the date of commencement from 8 June 2016 full stop unquote paragraph. While entertaining the present by issuing notice in the present writ appeal on 15th December 2021, this court had stayed the impugned order of the single judge. Paragraph. The facts in brief are that in terms of the aforementioned work order dated 29th September 2012, issued by appellant number 2, that is Paradip Seafarers Welfare Association, bracket PWA. The respondent was to undertake the work of single quotes manning, maintenance, and commercial operation of Port Seafarers Club unquote on payment of a license fee, comma, for a period of 5 years. Full stop. Under clause 5, the date of commencement was to be that the contract period was to commence open quotation from the date of commencement of work, i.e., furnishing the club cum hospital, comma, placement of staff, and effecting operation and maintenance, unquote, full stop. It was stipulated that, open quotation, at any case, the contract period shall commence from 121st day of issue of work order, unquote. Paragraph. Further, the contract could be extended for another period of 2 years, open quotation, on the discretion of the PSWA, unquote. Where do you get that whichever is earlier?
So that is at page 27. Page 27, clause 4. The contract period for 5 years commencing from so and so.
That
Or from
121st day of the issue of work order,
whichever is earlier.
open quotation, whichever is earlier. Unquote. Paragraph. Admittedly, the respondent did not commence the operations as envisaged within by the aforementioned clauses and sought for extension of time. By a letter dated 14th August 2015, PSWA informed the respondent that it was prepared to allow extension, open quotation, till 31st December 2015 for commencement of services. With the condition that if it failed to start providing services with effect from 1st January 2016, open quotation, then, the contract shall be terminated and your security deposit shall be forfeited, unquote. Paragraph. The work still did not commence by that date. And the respondent again wrote to PSWA asking it to treat the actual date of commencement as being from 1/8/2017, having a closing date of 1/8/2004, bracket 5 years plus 2 years. Paragraph. On 16 September 2019, the above request is declined, reminding with PSWA reminding the respondent that by the earlier letter it had been allowed time extension till 31st December 2015 to start providing services as detailed in the work order. Full stop. Paragraph. It is thereafter that the writ petition was filed, seeking the above relief. Paragraph. In the impugned order, the learned single judge has referred to para 10 of the counter affidavit filed by the appellants to conclude that since the respondent started providing services from 8 June 2016, the date of commencement should be the date of commencement, actual date of commencement of the contract. Paragraph. In the first place, as pointed out in the decision by Mr. Gautam Mishra and senior counsel for the appellate, a writ petition seeking alteration of the terms of contract should not have been entertained at all. Full stop. The legal position in this regard has been explained by the Supreme Court of India in Joshi Technologies International INC versus Union of India, 2015, 7 SEC 728. Paragraph. Factually also, what has been stated in para 10 of the counter affidavit filed by the present appellants in the writ petition reads as under. Reproduce the whole of para 10, page 44. The above paragraph reveals that the appellants allowed the respondent time for commencement of work only till 31st December 2015. Full stop. The 120 days from the date of the work order came to an end way back in December 2012. Full stop. The clause itself states the actual date of commencement of the contract would be either the expiry of 120 days from the date of the work order or from the date of commencement of work, open quotation, whichever is earlier, unquote. Therefore, the date of commencement of contract could in any event not have been taken to be 31st December 2015, full stop. Be that as it may, there is no admission in para 10 that the date of commencement of contract is 3rd June 2016, 8th June 2016. Full stop. It only notes factually that the respondent began work on that date. Paragraph. Viewed from any event, therefore, by the time the learned single judge heard the writ petition, the period of contract was long over. Full stop. There was no question of, therefore, the learned single judge reinterpreting the terms of contract, resetting the terms of contract to fix the date of commencement of the contract as 8 June 2016. Full stop. The said conclusion being both legally and factually erroneous is hereby set aside. Paragraph. As of date, there's no question of the respondent continuing to occupy the premises on the pretext of providing services under the contract in question. Full stop. The contract has long come to an end. Full stop. It is seen, paragraph. It is brought to the notice of this court by Mr. Nayak, learned counsel for the respondent, that against an order dated 13 January 2023 of the estate officer, Paradip Port Authority, in this case number 20 of 2022, the respondent asking the respondent to vacate the premises within 15 days from that order, date of that order. The respondent has already gone to the district court at Jagat Singhpur
under the PP Act, under the said Act.
In what proceedings?
Lord, this is under the public premises.
No, case number.
Lord, this case number.
And an interim order appears to have been passed in its favor in those proceedings. You must be having a copy of that.
No, I will get a copy.
Paragraph. It is therefore plain that without any authority of law, the respondent is continuing in the premises beyond the period of 5 years, which has expired, whether one takes the date to be as per the contract or date as claimed to be by the respondent. Full stop. In other words, there's no legal justification for the respondent to continue to occupy the premises. Paragraph. For the aforementioned reasons, the impugned order is hereby set aside and the appeal is allowed with no orders to cause.
And I didn't want to disturb your lordship's entry number A in the list of dates. The period 121st day would not be December, but 1st February 2013.
13.
Instead of December.
1st February 2013, that 120 days.
We are grateful.
Item 49.
49, I am for the appellant. I have passed on the similar orders passed by my lord. See, the matter is pending for the larger bench of the
Lordship has posted to 30th August 2023, my lord.
All right. Yeah, can come on 30th August.
Or same order.
Same order there.
This order. All right.
Item 50.
Learned additional government advocate has served me just now a copy that stating inter alia that
In compliance to my lord's direction, we have reinstated him in service subject to outcome of this writ appeal, my lord.
Oh.
I have given that copy, my lord, for my lord's.
The PCCF is there. All right. The PCCF is present in virtual mode. Copy of an order dated 17 May 2023, reinstating the appellant as forester, subject to the outcome of the present writ appeal, has been shown to the court. No further orders in this regard is called for. The PCCF need not be present hereafter. Very good. List for final hearing on. September 5th. You change the number. All right, same one. Great.
Item number 3.
Memo taken on record. Dismisses withdrawn.
Item number 4.
Wait, please, my lord. I'm appearing on VC minutes. On behalf of Mr. D.K. Mahapatra, he has instructions to appear for petition number 1, my lords. He is unwell. I pray for an adjournment.
What's the matter about?
I beg apologies, my lords, but I do not have the file with me.
Seeking quashing of FIR
What
under Explosive Substance Act.
Explosive substances. So, ALBL. It's only being adjourned from time to time. Nothing has happened. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
Item 5. Item number 5.
Yes, dismissed.
Item number 6.
But item number 5, that my appearance for opposite party vigilance may be noted.
All right. All right. All right.
Item 6.
Same order.
Item 7.
Same order.
Item number 8.
Same order.
Item number 9.
Item 9 permitted to withdraw my lord with liberty.
Okay. Permitting the petitioner to raise all these.
Item number 10.
None appears dismissed.
Item 11.
My lord, item 11, no instructions. My lord.
No instructions dismissed.
Item number 12.
Item 12, my lord, not pressed. My lord.
Dismisses not pressed.
Item number 13.
Item number 13, I am appearing in VC, my lord. I pray for a short adjournment because this is a case involve the complainant of a private party. I have made the complainant as a opposite party. My instruction today I have received that matter has already been compromised. By the next date, the opposite party will appear and file the affidavit. I only seek a small adjournment because they are arising out of a complaint case. My lord.
No, this is 1861.
My lord.
That is NDPS Act.
I beg apologies, my lord. I am 13, my lord.
Sorry, yeah. None appears dismissed.
Item 15. Sorry, item number 14.
My lord, item 14, 15, my lord, default bill, my lord. Kindly
Lordship, up to after vacation, reopening week.
14, 15, 17, 18.
That is, Lordship, that is to examine the applicability of the decision because of the Honorable Appeals.
Latest.
That is reopening week, 26th of June.
All right. List on 26th June.
Before the
14 and
Lordship.
15. Yeah.
Item number 16.
None appears dismissed.
Item 17.
17, 18 also, my lord, default bill, my lord.
26th June.
Item number 19.
Also, item 19, liberty may be granted to raise all the pleas.
All right. Permitting the petition.
Item number 20.
I am in the VC, my lord. The same, my lord. This is arising out of a complaint case. I have made the complainant as a party. Instruction is that, my lord, the matter has already been compromised. This is a case, my lord, however, I have challenged the cognizance order. The present petitioner was working as a my lord, public servant, as that by then she was working as the inspector in charge, and the complainant is a private party.
No, but this has never come up for hearing even once.
My lord, yes. It was
by this time, we could have easily got the affidavit.
2062 of 2021, your lordship.
Correct. It has not been listed once in the last 3 years, 2 years.
My lord, 1/11/2021 is the last order. I've taken the notice was issued to the opposite party.
When? Sorry?
11/11/2021.
Yes, my lord. 11/11/2021. The notice was issued. Today, I have obtained the instruction since arising out of a complaint case, my lord.
There's no such order, 11/11.
Our record also shows, my lord, notice has been issued.
Yes, my lord. The notice was issued and the stay was granted.
There's no such order in the file.
My lord, Justice S.K. Mishra's order.
Yes. Copies also, my lord.
There's no order. Sir. It's only listed on 11/11, but there's no order passed on that day. Oh, so it touched the end. Oh, sorry, sir.
Mahal.
All right.
Yes. Lordship, I call this matter only after reopening.
No, 1 minute. Let's see the service, notice service.
Yes, ma'am.
Nothing prepared. Process fee. No process. No process fee also was filed. Obviously, you didn't file process fee, sir, last time.
We have filed all the requisites, everything, and thereafter.
No, the file notice doesn't show that any requisites were filed.
I'll comply the defects, my lord. But my instruction, by the next date, your lordship may put up this matter any date, so that the opposite party, the complainant itself, will appear, my lord. That is my instruction. Your lordship, only simple. Your lordship may take up this matter in any other day.
Counsel for the petitioner claims that the matter has been compromised between the petitioner and opposite party number 2, and that it takes to file an affidavit of opposite party number 2 by the next date. List before the roster mentioned 7th August.
21.
Okay.
Item number 21.
Nana Pierce.
22.
Same order.
Item number 23.
Raise all the point.
All right. Permitting the petition.
Item number 24.
Liberty may be granted to.
Same order.
Item number 25.
May please, Your Lordship. Your Lordship, the present petitioner has challenged the order passed by the district and session judge Jajpur at page 40, Your Lordship, wherein the present petitioner had been acquitted in an appeal of from 138 NI Act case, Your Lordship. And subsequently, we had filed for the release of the amount that we had paid under Section 148A, Your Lordship. Since we had put up the application before the SDJM first, that is why the SDJM had held that since it lacks jurisdiction to release the same amount. And on the same ground, the learned district and session judge has also rejected our application, Your Lordship. Lordship, we may be given the liberty to file a better application before the appellate court, Your Lordship. Appellate court below, Your Lordship.
Better affidavit.
Application, Your Lordship.
What application? What will you file it under?
Your Lordship, application under Section 148A to release the compensation amount, Your Lordship.
No, it has to be filed before the SDJM.
Your Lordship, but the SDJM has himself held that it is out of jurisdiction since it is in appeal.
All right, it is clarified that the impugned order of the learned district and session judge Jajpur will not prevent the petitioner from filing a proper application under Section 148 capital A.
Yes, Your Lordship.
Of the Negotiable Instruments Act 1888 for release of the amount deposited in court at the time of admission of appeal. With the above clarification, the present petition is disposed of.
Item number 26.
May I please? Here, my lord, the petitioner filed an application under Section 311 of CRPC to recall witnesses, my lord, for further cross-examination. Same was rejected by the order, my lord. Your Lordship may see Annexure 3. Running page 19, my lord. Court rejected, my lord, bottom page, the Lord Defense Counsel.
What's the reason for recall?
My lord, in fact, she is mentally unsound, my lord.
Now, all the more why you should not be recalling. Then don't recall.
My lord, in fact, that is the ground of dispute between the parties.
Recall, sir. That you can't recall the witness for that. Yes.
And that apart, my lord, some question relating to torture.
You not produce that questionnaire at all.
Yes, ma'am.
Yes, my lord. Your Lordship may direct, I will file fresh application with specific question.
No question. You had enough time to do all that, sir.
Lord, your Lordship may see the...
Even now you don't have this questionnaire.
My lord, the question.
My lord,
posted for argument, my lord.
My lord, I will confine my prayer to the PW 1, 8 and 11. Only 3 witnesses, my lord. Informant and victim and his sister, my lord.
Not
with specific question, my lord.
Sorry, sir. Sorry.
A date may be fixed. In that date, I will my lord, file the application, and within 10 days that will be disposed of.
Sorry.
With that liberty, my lord, your Lordship may direct.
Sorry. Present petition challenges an order dated 24th March 2023, passed by the learned ASJ Chandi Court in CT case number 123 of 2017, rejecting the application of the petitioner accused under Section 311 CRPC.
And that recall of one thing, my lord, the court below during course of the my lord, examination reflected that in fact she is mentally unsound. That my lord, court below has reflected. I will file the evidence copy, my lord. Your Lordship may permit me.
The application was made after the entire trial action had concluded, and the case was posted for arguments. Paragraph.
One chance.
The questions that the accused intended to put to the witnesses sought to be recalled were not placed before the trial court. Even today, the situation is no different. Stop. Paragraph. The court is not persuaded that the impugned order suffers from any legal infirmity. The petition is dismissed. A copy of this order be sent to the concerned court forthwith.
27.
I plead your Lordship. Lordship, here the non-bailable warrant of arrest was issued by the Annexure 2 series at page 15. Lordship,
307, madam.
307 and other offences. Lordship, it's actually a fact that between the it is a group, it is a dispute between two groups of villages for the establishment of POSCO steel at Ersma locality. That the POSCO steel that has not been commenced till today. and relating to that issue, the case has been posted. In the 307, there is no material at all. And in the meanwhile, warrant has been issued by the annexure 2 series at page 15.
When was that issued, sir?
Let's see, it was issued on 7/12/2022. After charge sheet was submitted way back in the year 2011.
And you were on bail when?
Yeah, but I've not gone through the bail has not been in my favor.
You've never?
Yes, yes.
You were never arrested then?
Yes.
Then where's the question of bail? No question at all, sir.
Let's see, warrant has been issued. The 307, there is no material at all.
This is not the stage for deciding all that. Not inclined, sir.
Would permitted to
counsel the petitioner seeks to withdraw this petition, dismisses withdrawal. Put on the paper.
Liberty may.
Copy of the
Let's
will
may.
be sent for both.
Liberty may.
28.
None appears dismissed.
Item 29.
29, your lordship is permitted to withdraw.
Or dismisses withdraw.
Item 30.
Item 30 permitted to withdraw.
Or
Liberty may.
No, what liberty, sir? I don't understand. Liberty for what? Dismisses withdrawn. Yeah.
Item number 31.
May it please, Your Lordship. Your Lordship, the present petitioner has challenged the initiation of criminal proceedings against him on the ground that a criminal action cannot be initiated on when there is a default in the repayment of a loan, Your Lordship. Your Lordship, the facts giving rise to the cause of action is that the present petitioner had taken a gold loan from an SBI branch, Jaleshwar, Your Lordship. And in the meantime, he had defaulted in paying certain loan amount, Your Lordship. There was exchange of notices between the parties, Your Lordship. In the meantime, it was found that the gold that was pledged, that was found to be spurious in nature, Your Lordship.
That's the whole point.
Your Lordship, but that is, this has happened only after I have defaulted in my payment, Your Lordship.
Naturally, that's when they went and saw what gold you've given. Then they found it's all fake.
Your Lordship, but it is the bank itself which determines the nature of gold when I'm hypothetical.
So obviously, they did not do what they should have done. What do you wish to do? Want to withdraw?
Your Lordship, Your Lordship may call for instructions because this is purely a matter.
No, it's not that kind.
Your Lordship, even
actually, you got off very lightly. Only 420, 406. Charge sheet has not been filed yet. No. You will find many more provisions added
Your Lordship,
by the time the charge sheet is filed.
Your Lordship,
many more provisions.
Also, Your Lordship, I may be given some time to at least repay the remaining amount, Your Lordship.
Oh, you don't say all this, it will get you into further trouble. All right. Permitting the petitioner to raise all fees at the appropriate stage. The petition is disposed of. All right.
32.
Yes.
32.
None appears dismissed.
Item 33.
May I please, Mr. Lords, the petitioner before my lord seeks the indulgence to challenges the order of cognizance, my lords, on the ground of compromise. In the meantime, the prime accused of the case case against him has been quashed by a coordinate bench of this honorable court, my lords.
That's all right. What are you wishing to say? The co-accused is, what is the offense?
Offense is 420, lords. 419, 420, 468, 471, and 409, my lord.
So that 468, 471, all that's where the problem starts.
Lordship,
my lord, I am appearing for the informant, my lord. Matter has been settled between parties.
they had appeared in the other case also, case in hand, my lords. I'm supplying the certified copy, my lords.
All right. List before Justice R.K. Patnaik, who has passed the order in relation to the co-accused in criminal miss case number 852 of 2022. We'll have it tomorrow.
Lords.
Tomorrow.
Okay.
Much. Item 34.
May please, your lordship. And this is challenging the order taking cognizance. Madam, I am conscious of the limitation. May I be permitted to raise it at the stage of charge, ma'am?
Correct. permitting the petition to raise.
35. I mean, pardon, Lordship, I've served a copy. Lordship,
Yes,
my
yes.
learned senior may take
Yes.
instructions.
Yes,
with
yes, yes. That earlier one you say copy served on the. Yeah. All right.
35.
None appears.
Item number 36.
My lord, may I please your lordship I am in virtual mode, my lord.
Yes.
Here, my lord, the matter has been settled between the parties, my lord. Annexure 3 is the affidavit filed by the informant that he doesn't want to place the continue the litigation.
Who's appearing for them?
My lord, Mr. Biraja Prasanna Das is appearing.
For OP2.
Notice was issued to opposite party
Go
number.
by this affidavit? It's been settled? All right. Counsel appearing for OP number 2 confirms the affidavit filed by OP number 2 that stating that the disputes have been settled. That view of the matter taken in the prayer clause and all proceedings consequent thereto hereby quashed.
Obliged, my lord, deeply obliged.
37.
37, my lord, noting is that the AD back from OP number 2 without signature.
What is the matter about?
Deputy, my lord, the complaint case was filed arising out when the matter was sub judice before the civil court or by civil suit was filed. Lordship can see in the page 12, my lord. The complainant himself admitted in the para C the pendants of civil suit arising out of the self-same cause of action. And this is as in first state.
307 and all is there, sir.
My lord?
It has 307 and all that.
No, 307 is not there, my lord.
Yes, yes.
Lordship, see the page 20, my lord.
Yeah. This is many more additional factors.
Additional fact, but it is a fact that my lord, suit is pending. Otherwise, you lord permit me to
Yeah. Permitting the petition to raise all pleas at the appropriate stage.
Yes.
The interim order is petition. All right.
Item 38.
38 permitted to withdraw.
Permitting to raise all pleas. That's what it is.
Item 39.
39 permitted to withdraw and raise all the points.
Permitting to raise all pleas.
Item number 40.
None appears.
41.
Liberty may be granted to raise all the points.
41.
Item 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Item 44.
44 and 45 may be permitted withdrawal.
All right. Dismiss is withdrawn.
Item 46.
None appears dismissed.
Item 47.
Same.
48.
Same.
My lordship, on behalf of Mr. Sambit Samal, item number 48, 49 and 50 not raised.
Not raised. Dismissed.
Item 51.
All the points raised before the trial court. Right?
All right.
Item 52.
None appears dismissed.
Item number 53.
Here, my lord, the petitioner number 1 is the victim. Petitioner number 2 is the husband, who is the accused male.
Okay.
And,
age and all corrected by pen.
My lord?
Age corrected by pen. What is the real age?
After seeing, my lord, the FIR, I have corrected that.
I hope they are not minors.
No. They are not minors. They have married to each other. That marriage certificate is also annexed. That is, my lord, annex 3, my lord. Lordship will kindly see.
So you were to take instructions. What happens?
My lord, here, my lord, I have taken a...
Correct.
My lord,
I will take instructions.
My lord, I have...
No. Last time already you were to take instructions.
No. Today, my lord, I have taken instruction that the investigation has not yet been completed.
No. You have taken that instruction. He was to take instruction whether what you are saying is correct or not.
Marriage certificate, my lord.
No. That all that side.
That, my lord, petitioner is also the victim, my lord.
No. That's true. Last order was that you were to take instruction.
Lord, the 164 statement is there. My lord, CD I have received, my lord. Case diary I have received and 164 statement is there. Whether they have married to each other, I will take instructions, my lord.
Counsel for the state needs some more time on whether the marriage certificate produced is a genuine document.
And the petitioner is the victim, my lord.
Anyway, See, one thing is to see. That's the whole point. All right. Interim order to continue. List before the roster bench. 3rd August.
Yes.
All right.
Item 54.
54 मेरे liberty be given to register passport.
All right.
55.
Wait, please, Your Lordship. Your Lordship, the present petitioner has challenged the cognizance order dated 16/7/2020 on the ground that since this is a matrimonial dispute, Your Lordship, the case has been settled amicably between both the parties, Your Lordship.
You should produce the affidavit.
Yes, Your Lordship, the affidavit is at page number 32, Your Lordship. And
Your Lordship, I am appearing on behalf of OP number 2, the informant. The marriage has been mutually divorced, Your Lordship, and the affidavit is at flag B on record, Your Lordship.
What was the affidavit?
At flag B, Your Lordship.
Oh. No. Again. You sure this is the right matter?
Zero
2034. 55.
In item 55 called out.
We had called out 55 and therefore this is 56 what you're appearing. It's all right. That's why you got confused. So
We
55
apologize.
none appears dismissed. 56.
We apologize.
No problem. Counsel appearing for OP number 2 confirms the affidavit filed stating that the disputes have been settled. That view of the matter takes from the prayer clause. And all
In
proceedings
item number 55, my lord, there is a memo for withdrawal, my lord. In
55.
item number 55, my lord.
All right. Memo taken on record, dismisses. All right.
Item 57.
Question.
57.
On behalf of Mr. Bagh, my lord. He has some difficulty. He wanted some other day, but if the lordship want that.
Permit you to raise all, please, sir.
No. I will just then place 1 or 2 points. But the FIR has been lodged referring to the disputes of 2012 and 2013 and saying that he has come, the petitioners have come and abused and all those things.
What has happened? Any charge sheet filed?
My lord.
No.
Yes, my lord.
Charge sheet filed?
Yes, my lord. After that, my lord, cognizance has been taken. And also 3 SC/ST Act is there.
No, that is the grievance. Only 3 SC/ST Act doesn't come into play because there are Supreme Court judgments your lordship knows that it must be in a public place and touching the caste.
Correct. The trial court will consider all those judgments, sir.
May I seek one liberty that I may be permitted to raise the objections at the stage of the charge.
Correct. Permitting the petitioner raise all the pleas raised in the present petition at the stage of charge. The petition is dismissed.
58.
Item 58, my lord, is transport bill. I am praying for an adjournment.
What does that mean, sir?
A short adjournment.
No. What is the matter about?
My lord, the matter is that the informant is the proprietor of Mangala Traders. And the petitioner is the proprietor of Rai Chaudhary Traders.
Right.
Both were purchasing palm oils from Kargil, India, which is situated in Kakinada. The issue is that, my lord, the petitioner purchased through drafts, which was not delivered to the petitioner, and same issue was faced by the informant also.
Correct.
So the informant, without getting the purchased palm oil, registered an FIR. And the petitioner, in a subsequent stage, the FIR has been lost, my lord, due to a mistake of fact.
All right, sir. Permit you to raise all, please. Permitting the petitioner to raise all, please, at the appropriate stage.
My lord, it's a good case for passing, my lord. So I may pray for some time.
No. Sorry. Yes.
Item 59.
None appears dismissed.
60,
Same order.
61,
Withdraw, I raise the point before the law.
Permitting petitioner raise all, please.
item 62,
None appears.
63,
Same order.
item 64,
Same order.
65,
My lords, petitioners be permitted to raise all the points at the
All
basis.
right. Permitting the petition.
item number 66,
Your lordship, I appearing to VC, kindly permit me to withdraw your lordship.
All right. Dismisses withdraw.
Your Lordship, our appearance on behalf of OP number 2 may be noted, Your Lordship.
All right.
67,
None appears dismissed.
item 68,
None appears dismissed.
69,
Same order.
item number 70,
Same order.
71,
Same order.
72,
May I please, Your Lordship? I am permitted to raise all the points
At the appropriate stage. Yeah, all right. All right.
73,
None appears dismissed.
item 74,
May I please, Your Lords? FIR is under challenge. One stranger is lodged the FIR. There is no allegation from the side of the victim. Notice issued to the opposite party number 2 victim, but AD has not been written. May I pray for fresh notice, my lord?
Charge sheet must have been filed by now.
My lord, the stranger lodged an FIR that rape committed over the.
Sir, it was a stranger. These kind of offenses, anybody can bring it to the.
No, the petitioner has no mobility, my lord. He is a man of 75 years and the entire medical document I have annexed, my lord. Lost his mobility.
It's all right. 1 minute. Has charge sheet been filed?
No, my lord. CT has been called for. CT has come. 164 statement is there.
Oh. Then it's okay. Raise all the pleas at the
And
appropriate
medical
stage.
report is there.
Naming the.
Yes, ma'am.
Oh.
She claimed that the child is born out of their wedlock, my lord. I have annexed the medical document, my lord. The husband's name is there, my lord. Started from page 27 and 28.
Anyway.
And they corrected the husband name by virtue of an affidavit. That is under Annexure 3, page 21 to 26.
Raise all please, permitting the petitioner raise all please.
No, my lord. I may be permitted to withdraw to better application after taking cognizance, my lord.
No question.
Because of it is at the FIR stage, after cognizance, I will file.
This will cover all that, sir.
My lord, item number 75, 76 on behalf of Mrs. Jena, my lord.
Yes.
The investigation was completed, filing a final report, my lord.
Okay. So it's infractuous.
Infractuous.
In view of the fact that a final report has been filed in both cases, they've been rendered infractuous and are disposed of. Such.
Mine.
item 77,
None appears dismissed.
78,
None appears dismissed.
item number 79,
Same order.
My lord, I will remove the defect, my lord.
No. Tell us what the matter is about. What's the matter about?
One passover, my lord.
All right.
80,
Your Honor, on behalf of Mr. Misra, defect should be removed within 3 weeks.
Lord, charge sheet has been filed and cognizance has been taken.
Copy is
Yeah,
not
permitting the petitioner to raise all pleas at the appropriate stage. All right.
item 81,
My lord, kindly permit to withdraw.
Dismisses withdraw.
item 82,
82, my lord, I'm not pressed, my lord.
All right. Dismisses not pressed.
item 83,
Please, Your Lordship, may I please, Your Lordship? In this case, we have challenged the FIR, my lord. My
Yes.
name has falsely implicated in this case, my lord. Actually, the accused relating to this case, my lord, always been arrested and in custody, my lord. And they have confessed that they have done this attack, my lord, on the victim, my lord.
Lord, section 3 and 4
Out of jealousy, my lord, out of jealousy.
My lord, these petitioners have thrown bomb to the petition. These accused persons have thrown bomb to the informant, my lord, and also seriously injured. The informant has been seriously injured.
Oh.
My lord,
3 and 4 of the explosive act, my lord.
Yeah. Explosive substances is
Yes,
also
my
there,
lord.
madam.
actually, my husband has thrown the bomb, my lord. Our divorce case is pending before Bhubaneswar family to Bhubaneswar, my lord. who is staying residing separately since 2021, my lord. My name has falsely implicated in this case. I am not involved in this case, my lord.
It can be only decided at the time of trial, whether it is a false or genuine.
Madam, they have admitted that they have done this, my lord. We are residing separately since 2.5 years, my lord. Divorce case is pending. I am not connected, in no way connected with this case, my lord. I have also been attacked in 2022, my lord. My lord, page 13, my lord. They have admitted that they have committed the crime, my lord. And also admitted that husband and wife residing separately since 2021, my lord.
Investigation is under progress. Let the investigation be completed, my lord. Only this FIR was registered.
No, only thing is she's a woman. She's a lady.
Yes, my lord. Both husband and wife, they have conspired with each other. And also this incident has occurred, my lord. On 18/3/23, this FIR has been lodged. Investigation is under progress. Let it be completed.
No, investigation should go on.
Yes, ma'am.
No, but is she divorced from her husband? That's the only question. She's saying she's living separately.
Well, that is altogether different point. That will be raised at the appropriate stage, my lord.
No. Why should she, if she's staying separately, why should she get implicated? The case of the petitioner is that she's living separately from the co-accused. Bhagirathi Swine, who's her husband, and proceedings for divorce are also stated to be pending. Where is the divorce proceeding pending? Family court.
Family court, Bhubaneswar, my lord.
Do you have the case number in the family court at Bhubaneswar?
No, my lord, next time I will submit, my lord.
All right, paragraph. Let this fact be confirmed, verified. Let this fact be verified by the IAC.
Kharbal Nagar Police Station.
Investigating the case, list before the roster bench on 28 June. All right.
Item 84.
Obliged, my lord, deeply obliged.
The laches of the advocate not taking steps in BW has been issued. Earlier on bail, lordship.
Bail also, sir. Additional problem then, sir.
If the case has been already committed. Court of Sessions, lordship. And next to page 15, lordship. Accused persons are absent and take no step on behalf of accused persons and repeated call, they have found absent.
What is the offense? 307?
307, ma'am.
Only 307?
Yes, ma'am.
Let's say for 294, 307, 34 abuse.
All right. The petitioners will surrender before the trial court on June 2nd, June 2023. Till then, the NBW will not be enforced. It's made clear the stay will not continue thereafter. It will be open to the petitioners to seek appropriate orders in the trial court thereafter. All right. The petition is disposed.
86.
None of is dismissed.
87.
Same order.
88.
Same order.
Item 89.
Same order.
Item number 90.
Same.
91.
My lord.
I am appeal number 2. My name is trying to be recorded.
Come this side, sir.
My lord, in item number 89.
89.
89.
Ah.
It is an application challenging the registration of 1cc case number 302 of 2020 and the order of the cognizance dated 1/2 2/2021 passed by the learned JMFC, Jajpur Road, Jajpur, for the added commission of offence under section 294, 420 and 506 of IPC. That is still pending in the court of JMFC, Jajpur Road.
Charge sheet must have been filed by now. Anyway, permitting the petitioner to resolve please at the appropriate stage.
My lord, I want to make the kind submission of the it has been alleged on dated 10/11/2020. It has been alleged by the opposite party number 2 that the petitioner has tried to harass the opposite party number 2. Whereas there is proof that it is a travel certificate and the tickets that the petitioner was not there from the month of September to.
All this you show in the trial court. It has to be urged at the appropriate stage. All right.
Item 90.
I'm OP number 2. My name is
None appears to the petitioner dismissed. No.
Item 91.
None appears dismissed.
Both. Item 92.
My lords, on behalf of Mr. Panda, I pray for a pass for my lords.
All right.
Item 93.
May I please, Your Honor, the arising out of a 1/6 complaint case, my lord. Initially, complaint case was filed against the petitioner, my lord. Under section 420.
Number 2, Mr. Arijit Mishra. Where is he?
Last occasion, my lord, the Ashton report, he has not absent, my lord, 84/22. Prior to that, my lord, since the petitioners filed case 138 enact against the opposite party of 2, my lord, complainant. After receiving the 138 demand notice, my lord, a false case was instituted against the petitioners at Jajpur, my lord. And for that reason, my lord, there is a compromise, my lord, thing, my lord, last occasion, my lord, but the Mr. not appearing, my lord, simply urgent.
But some either notice has to go or.
Notice already go, my lord, Mr. Mishra.
Then you say the registry will inform.
My lord.
Mr. Arijit Mishra, advocate, to remain present on the next date. Who's appearing for opposite party number 2 to remain present on the next date. Before the roster bench. Interim order to continue.
Oblige.
List on 10th August.
Oblige.
Item now 94.
That's why item 91, the matter has become infructuous.
All right. Disposed of his instructions.
Item 95.
95%, matter become infructuous.
Same one. All right.
Item 96.
None appears dismissed.
97.
Same order.
Item 98.
Same order.
99.
99, my lords. My lord, the petitioner was paid for quashing the entire proceeding, my lord. Lordship, the allegation of the annexure 1, the FIR, page 12, my lord, is relevant. Here the BU has lost the FIR, intimating that the petitioner has submitted false BED certificate. That is the allegation. Lordship, see, the allegation that, Lordship, the page 12, parasecond. In the meanwhile, University Grant Commission, New Delhi.
Charge sheet filed.
Lordship, an order.
Charge sheet must have been filed.
Would that depend? I don't have an institution. Lordship, but Lordship.
All university fake certificate things, right?
Lordship, see, can you see?
Yes, the charge sheet has been filed.
Then you raise all please.
No, Lordship, see, the entire, there is no material to implicate this petition, Lordship. I am just.
Argue that in the trial court, sir. Nobody's.
Lordship, it will be a travesty of justice. Why I am saying so, Lordship? See.
You have to simply argue the stage of charge.
No, Lordship, see, Lordship, then. Lordship, kindly hear for me for some moment. Lordship, annexure 1, Lordship, see, page 12, my lord.
Yes.
They say that the university has been declared as a fake institution. It is declared. No, what is the date, my lord? Can you see? It is stated that the 7/10/2020 it is declared as fake. But my lord, the petition is my client. He is passed in 2005, my lord. 15 years before, my lord. So how the institution can be declared and how the petition can be liable, my lord? Let's see, because the let's see page 20, my lord. Page 20 and 3.
Yes.
Here, my lord, the petitioner has passed the BEd exemption in May 25, my lord.
Yes.
But the UGC declared the university in 2020, my lord.
Right.
So at that time, was my lord. And my lord, if Lordship see, and answer 7 also, the important document, my lord, see the page 14, my lord. Page, what's the kind? That's my lord. sorry, page, my lord, annexure 7, page 44. The Berhampur University has declared that the university in which my client will not pass, that is a genuine one. Let's say I'm just reading out the page 44, lordship. The Nabha Bharat Shiksha Parishad, Raulkala, Orissa under deemed university has been recognized by NCTAD, New Delhi, and allowed code number so and so. And there is written, and as per letter so and so, also last kindly see, last para. Hence, you are advised to verify. Sorry, sir, last the before line, my lord. The government and Department of Higher Education and letter number 4325, like 4216, Director SCERT Orissa, clarified that Nabha Bharat Shiksha Parishad Raulkala is equivalent with us, my lord. So it is a genuine university during that period, my lord, 26. So that is cannot be say that the certificate is a false one.
Now that the charge sheet has been filed.
Yes, ma'am.
And the petitioner has been named therein, it will be open to the petitioner to raise all pleas urged in the present petition at the appropriate stage.
May one thing. This order was passed
at the stage of charge.
One order has been passed by this honorable court to file an affidavit by the state. That is Lordship Sheet 3 to 22. Kindly see, Lordship, page 5 is the relevant portion. The order 3 to 22.
List of fake universities are there, my lord.
Yes.
And also this university has been included in the fake university, my lord. So far as the Odisha is concerned, my lord.
But that is in 2020. And if my lord been accepting that, can the petitioner be liable, vicarious liable? Because there is absolutely no role of the petitioner to run or open the university. Well, he is merely a student. If this is allowed, then every student who was passed from the university will be against them, there will be prosecution. So it is the government who has to see that university whether genuine or not, but they have to check, my lord. So they have failed. Rather, the university should have been made the accused, not the petitioner, my lord.
Sir, did you actually attend classes?
My lord?
Did you actually attend classes?
Yes, my lord.
That's the whole problem. You're not sure of that.
No.
Producing a certificate is one thing, actually attending classes, writing an exam, passing the exam, then the university after many years after you pass the exam being declared fake is another thing.
But the record says, my lord, they did that.
What is your version? When did you pass? When did you write the exam?
2005, my lord. 2005?
No, that's the date of your certificate.
Yes.
I have, my lord. How many years course is this? What is this? What did you get?
Regarding that, my lord, I have to examine. But this
B.Ed certificate means there was you should have hall ticket. You should have written exams. There will be a mark sheet.
Yes, everything not is there.
Where?
I have been issued with the admit card, my lord.
What?
Annexure 7 is the admit card issued by the university.
No.
And my lord, Annexure 4.
Where is your mark sheet?
My lord.
Where is your mark sheet?
My lord. My lord, that is not disputed.
What is that?
They only say
What is that not disputed? What's the question of dispute?
They say that the certificate is not genuine. That is the whole.
That's one. Did you actually sit for an exam? Did you write an exam? Did you get a pass mark?
No, I can produce one. I can produce. Because I have the main certificate, the pass certificate is with me. I have produced. And the University of Berhampur University also certified that the degree is genuine, the university is genuine, my lord. No, the record says, my lord, for which this honorable court has sought to file an affidavit, directed to state to file an affidavit.
What happened?
That they have not filed affidavit.
Why did you not file the affidavit?
The order is very clear, 3/2/2022. The honorable singles were not entirely quoted. My submission and relying on the Annexure 7.
A detailed order was passed with the court.
They have to file an affidavit. That is all.
2022 requiring the opposite party state to file a short reply. The said order be complied with positively on or before 1st July 2023. Just before the roster bench. On 10 July. 3rd July, you say 10 July. All right.
that intent to contribute.
Nothing's going to happen, sir. I don't think anything.
What was initial there, my lord? Initial intent was there. Initially intent was there.
It's all right. Not necessary.
His lordship is just serving. That is
Nothing
the
will happen.
difficulty.
Nothing will happen.
If
Yes.
ultimately accepted, my lord, the
Nothing will happen. Yes.
lordship placed.
Item 100.
None appears.
Pass to matter item number 79.
My lord, I pray for my lord. Today is my senior brother's 11th ceremony.
Okay.
I
All right.
inform-
Counsel for the petitioner has stated with some difficulty. This for the roster bench on 4th July.
Item number 92.
Please, my lord. My lords, these applications under 482, my lords, were filed pursuant to observations of the Honorable Apex Court at Annexure 12, your lordship may see in the first CRLMs. Annexure 12 is at page 49. Lords, the petitioner had approached the Supreme Court under Article 32 for quashing of the criminal complaints affairs, my lords, which are the subject matters of all these CRLMCs. And the Honorable Supreme Court, my lords, at page 50 said that the petitioner could move this Honorable Court for quashing of the individual criminal cases or complaints.
No, basically, they said it does not bar.
Yes. And therefore, my lords, the petitioner was constrained to file these CRLMCs because in all these cases, my lords, wherein he has been implicated as an accused because of the fact that for a certain period in 2000, he was appointed as the chairman of the Orissa Rural Housing Development Corporation, certain affairs were lodged which led to the petitioner's service career being marred, my lords. After the affairs were lodged and charges were filed, the trials were not commencing at all, my lords. So therefore, the petitioner had been constrained to move the apex court.
Now, in every case, trial is on, sir.
No, my lords. In every case, trial is not on. I am telling where cases trial has not commenced. In CRLMC 1780, my lords, I have been convicted. So that has become infructuous.
So let's now, 1780, you say this petition, since the trial is concluded and the petitioner is convicted, this petition has become infructuous and is disposed of. Then,
Lords. 1628 also the same.
Same thing, 1628. Yes.
Lords. Then, my lords may see CRLMC 2080 of 2021. 2083 of 2021. In all these cases, my lords, the trial has ended in convictions.
All right. 2080 and 2083 also.
Now, so far as CRLMC numbers 1645 of 2021, 1647 of 2021, then 2077 of 2021, 2078 of 2021, 2079 of 2021, 2084 of 2021, and 2085 of 2021 are concerned. Charges are yet to be framed in these cases. They are all cases of the year 2015 or 16, my lords. This is the state of affairs. In the rest of the cases, my lords, maybe one witness has been examined, maybe somewhere four.
No, they filed a detailed report saying how many witnesses in each. So there is some.
I don't have a copy of that, my lord, so I'm not sure.
There's in the
If
first.
they filed a report, my lord, the copy should be given to me, my lords.
Anyway, we can expedite there, and all those matters we'll expedite. We'll make it time bound.
My lords.
Yes, what has happened in this case, so far my instruction goes, a report was called for from the trial court regarding all those 28 number of cases. And in so far as the delay part is concerned, my instruction goes, somewhere either the petitioner, due to the non-cooperation of the accused persons or the petitioner. The
Of
delay
course, that is always there, my lords. I will not dispute.
On one hand, if the accused persons are delayed, accused person, other hand claim the benefit of a delay. That
That
cannot
is
be permissible.
because of the attitude of courts, my lords, that they also, my lords, they pass the buck to the accused always, my lords. I am sorry, my lords, to say that this is the reason that is being said by the vigilance in every case, my lords. Wherever a petitioner comes to the court, as though the petitioner comes to the court as though it's a luxury for him, my lords. Everywhere, my lords, they say that I am responsible for the delay. The court does not have the time, my lords, to call for the records and see who is responsible for the delay.
All right. Anyway, yes. We'll expedite it anyways. All these trials can be expedited.
My lords, what purpose does it serve, my lords? Can I be made to face trials, continuous trials, for one particular instance by splitting it up into each, my lords, loan that I have approved? That becomes a separate case. How many cases, my lords, I will face trial and be convicted?
Yes. All right.
And on what basis, my lords? I have just approved, my lords, sanctioned loans which were recommended by my subordinates, my lords. For that, my service career has gone. I am out of a job now because of the convictions, my lords, imposed on me. And now, my lords, your lordship is saying, in cases even when charges have not been framed, your lordship is going to expedite it, my lords.
No, not charges framed. We have details of all those TR case numbers where the trial is in progress, but at various stages.
No, then let a copy of it be served on me. Let me go through and let me make submission. Your lordship may call it tomorrow. Let me make submission.
Anyway, those other cases where you say charge sheet has not been filed will give a different direction.
My lords, I myself told your lordship which cases have become infructuous. Why do they become infructuous? Because they are not taken up in this court. There is direction for listing, but matters don't come. Please look at the order sheet, my lords, to when it was adjourned after notice was issued, and where after that where it has been listed.
Right.
And always, my lords, the Vigilance Council says that I am responsible for the delay.
That in the records is.
All right.
Am I going to file memos every day, my lords, because my matter is not being listed?
All right. All right. So those other cases, you see in all these petitions, Mr. Panda states that till date, charge sheets have not even been filed.
No, charge sheets have been filed.
No, you gave me a list of cases where charge sheet, you said investigation is not complete.
My submission is charges have not been framed, my lords.
Oh.
All cases, investigation is complete.
Aha.
The court doesn't frame charges and I am not cooperating.
All right. You see in all these cases, he says the charges are yet to be framed, although charge sheet has been filed. Full stop. Permitting the petitioner to raise all the defenses he has at the stage of charge. These petitions are disposed of. The remaining petitions, you say a report has been filed, a status report has been filed by Superintendent Village Agents Bhubaneswar in Criminal MC 1780 of 2021, sorry, giving the present status of the various trials against the petitioner. Mr. Panda states that he should be given a copy thereof for him to examine and make submissions. Full stop. The registry will provide to Mr. Panda a copy of the above document, which has been filed in Criminal MC 1780 of 2021 within 3 days. So the remaining matters you say list on 17 July before the roster match. Right. Right.